much, Minister. Over to you, teacher. However, Minister, there is one target that you did not meet. You did not go to the stadium as agreed, and that's why we lost.
Yeah. The workshop.
Yeah, no.
Next time.
No. That one is a serious target to be met.
You can only guess, Chair, who was at the stadium. Thanks, Chair, and good morning to the honorable members of the portfolio committee. If the colleagues can just fly so that it will make matters easy. But just as a way of an opening, as the minister indeed said, I want to confirm, Chair, that those matters, starting with the appointment of people living with disabilities, which previously the department was outside of the 2% target as required by prescripts of government. And then the previous year it was achieved. We have therefore adjusted it upwards, starting with the year 2023-2024 to 2%, at 2.2%, I'm sorry, as opposed to the 2% that we had presented here. So we've adjusted it upward to 2.2%. And with regards to the value of briefs to female practitioners, the target was set at 28 in the previous year, and we obtained 29%. We have now adjusted it to 30% starting this year to move into the next 2 to 3 years of the MTEF. And the third one that was raised as well as a concern was the addressing of fraud and corruption in the department cases. So we have adjusted from 70% to 80% as a minimum, but not as the ultimate, meaning that that's the minimum that we should not fall below. Otherwise, then if possible, we should be able to achieve 85 to 90% once the labor relations unit of the department is properly capacitated. Those were the two. Now, the overall indicators in the previous year that has just ended, they were 91. The current indicators for the whole APP is sitting at 96. Now, then there are indicators that you will see that they don't appear in this year's APP because they were time bound. They were 1 year indicators. I think we did give an example of the conferment of Silk guidelines, that the guideline, there was never a guideline for all the years. Silk was conferred without guidelines that were guiding the process. So the guidelines have been developed and they have ended. So therefore, it was no longer necessary to proceed and have them this year. Those are the ones, but I'll ask Mr. Gelebe to just go and introduce the new indicators. I think there are not many, about 3 to 6 of them, which were not there, and they will not have a base to grow from. Just to take us through those ones. Mr. Gelebe, the new indicators.
Thank you and good morning, honorable members of the committee, DG, Minister, Deputy Minister, and colleagues from the Department of Justice. I'm going to indicate the following before I go to the changes that we effected after the discussion we had last week on Monday. And as the DG indicated that currently as on the APP, we're sitting with 96 indicators. And the indicators that were time bound, as the DG indicated, and those in some instances we do the consolidations in those indicators that we
sorry,
don't have them on the APP in this. Hello?
I apologize, Fatu. Can you please indicate which slide so that I can flight the correct slide, because we're not going to be going through all the slides. So please direct me to which slide you are speaking, and I'll follow from.
I'll direct you after this opening remarks that I want to make.
Go to the target straight.
The line of Mr. Gelebe's line is very bad. Can we try Mr. Tabiso Titi, if you can, from your side? Mr. Gelebe's line is completely bad.
Am I audible now, DG and members of the honorable members of the portfolio committee?
Yes, you are.
Am I audible now?
Yes,
Let me go. Okay, let's go. You can move the slide, Calais, to the tables. Next slide. Next slide. Next slide.
Slide number 9.
Next slide. I think the next one that's coming, where you start showing the Ali, next slide.
Can't you just give her the page so that she can go to the page?
And if she can go to the next one. If she can go to slide number 10. And on that slide, we have got two indicators. The first one is the percentage of total workforce position occupied by people with disability. We then adjusted the target from 2.1 to 2.2, and we also adjusted the medium-term targets for 2024, 2025, and for 2025 and 2026. The other indicator that was also affected here is on the slide 10 is indicated 2.10.4, which talks about percentage of reported corruption cases investigated for official finalized. The target we have 80% above the performance. And again, if I proceed under outcome 3, we also assessed the audited performance for outcome number 3, where we had a target of 300, where we planned that we will do public education communication activities, and we then look at the audited performance, which was 394, and we adjusted it to 400 going forward for 2024, 23-24, and we also adjusted the target accordingly over the MTF period. And again, under outcome 4, these are the changes that we did. We didn't only look at the 3, we then did a total assessment of all the indicators. Indicator 4.1, which is on 4.1 on slide 4.3 on slide is 17. We adjusted the target from 91 to 92. This indicator was not aligned with the audited performance. That's where we look at the resource challenges that we have and then agreed on 92. And still, again, on that slide 17, indicator 4.5, which is the number of NRS or clearance certificate issued from the backlog. We then reconsider our target after we look at what was the figure on the system, and we committed that in this financial year we'll make sure that we clear the backlog of 7,896. In terms of the slide that follows after that, which is indicator 4.81 and 4.91, this indicator talks to the a family advocate matters, litigation matters, and non-litigation matters. The previous performance was sitting at 92 and 91 respectively. However, after we discussed and consider
Sorry,
still the same slide 18. Within 90 days from date of
Mr. Gelebe, your system, please. Mr. Titi, can you try and take over from your side? Mr. Gelebe's system really, they can't hear anything. The new indicators.
Am I audible now?
Yeah, I think Mr. Gelebe didn't hear when we requested that he goes to the new indicators, so that's why he's just going through the entire presentation.
Kale, you will help me there.
I'm continuing.
If you do, and it's clear, Mr. Gelebe, just go to the new indicators that didn't have a baseline. That's what we requested, that you only go to the new indicators that are added for this year. But your system is bad. If Mr. Titi could try from his side.
I'm in his office now. Am I audible now?
You are. Maybe let's hope we maintain it there. Can you move to the new indicators for this year, please?
The new indicators for this year that we included on the APP, if you look at the slide from slide from slide 20, National Strategy for Domestic Violence, report on the review of a small claim court, decree of divorce, domestic violence protection order, those and the framework for foreign language interpreting, and the National Conference on the Review of the Criminal Justice System. But in terms of the targets on the protection orders and the degree of divorce, we agreed that we must make sure we set a target for ourselves, which is 95%. And under program 3, we also included new indicators, which are the National Conference on the State of Human Rights in South Africa. We also included the ratification of international instruments on the APP. We also included the indicator. If we can go to slide I want to slide 31, where we included a constitutional dialogues to be held to advance constitutionalism. And we also included another indicators that will be a number of awareness that will be done with the community advisory officers. And we also included the number of advice offices that we are going to capacitate in this financial year. And we will also deal with develop a framework on international relations engagement and submit it to the DG for approval. And that's, and as I indicated earlier on, the National Conference on the State of Human Rights. And when I was covering outcome 3, I indicated those indicators that like the legal framework on the foreign language interpreting, the conference on the review of the criminal justice system, and also the protection orders, the tabling of the annual report on the Child Justice Act. Those are the indicators that we included on the APP, and in total, those indicators that we included on the APP, there are 15. That's why we are sitting with the 96 as compared to 93 that we had in the previous financial year. Thank you, DJ.
Chair, just to mention that there are 2 indicators who will desire to sit at 100%. That's the serving of protection orders on domestic violence, but it's a new indicator we have. So we are starting at 95 as we're building a base and then a capacity and the systems in place. And then our desire is that in the coming years, maybe the following year, then we can move to 98 into 100%. And the same as well is on the divorce matters. So they are new in the APP. So we're starting at 95% due to a lot of dependencies, including our system that we are rebuilding, as well as the challenges related to availability of power supply across our different courts, and also the training that we have to conduct to build capacity in our personnel. So we hope that starting from 95 should be easy for us as a minimum, 95% as a minimum. Where we're able to do 99%, it will still be a great achievement. But ultimately, in a year's time, we want to be at 100%. Thank you very much, Chair.
Thank you very much, DJ, and to your team. Members, that is the presentation from the Department of Justice on the issues we raised last time. Any comments? I don't see any. I think that is fine. DG, Minister, Deputy Minister, I think you can now submit.
Our indebtedness to you, Chair, before Minister take over, we continue to say Yinde Lendle.
No, thank you very much. Thank you very much.
Thank you very much, Chairperson.
Thank you very much. The NDPP is on the line.
Chairperson, can I request to be excused?
Okay. Okay. No, that's fine, Minister. Thank you very
Chair,
much.
if I can also be excused, and I think the relevant officials from the department who'd come for the earlier presentation that's just been done would also want to leave, so that you're left with those that you should be with for your presentation.
Okay. No, thank you very much.
Thanks, Chair.
Thank you very much. I think let's welcome the NDPP and her team from the NPA. NDPP, are you on the line?
Yes, Chair, I am. Sorry, I'm just trying to unmute the video. Hopefully, you can hear and see me. Right? Good morning, Chair. Good morning, honorable members.
We can see you, but your voice is not good.
So sorry, is that better? Is that better, sorry?
It's not good at all.
Okay, can you hear me? Okay, can you hear me?
We can hear you, but your voice is not great.
So I'm going to start with bringing the laptop closer to you and speak louder. Is that better?
No.
Sorry, Chair.
Yes. See.
Yes, and NTPP, do you, if you perhaps have a earphone device with a mic, because I think we are using the laptop speaker and it's not doing justice. Can they maybe something, maybe your earphones with that mic, because the laptop speaker is not doing justice. The laptop mic we are using, or if they can find an alternative laptop to use.
Thank you, honorable members. I
You
have
are
my
clear now.
Yeah, clear now.
yeah, I'm clear now. All right. So we've changed something here. My colleagues from IT have assisted. Hopefully we'll be able to proceed now.
You
Is
can
it
proceed, NTPP. Yes, you can proceed.
Okay. I'm just trying to get my presentation on my side. Can I get it on the desktop? Sorry, Chair, just give me a moment. There's too many open. All right. All right, thank you very much. Honorable Chair, honorable members, good morning. I also want to say good morning to members of the public and the media who might be following this important briefing this morning. I want to also welcome senior managers of the NPA who are present with me today, the Deputy National Directors of Public Prosecutions, Advocate Rabaji Rasitaba, Advocate Anton Duplessis and Advocate Rodney de Kock, as well as various special directors and our colleagues from strategy and finance. Chair, we appear before this committee at, I think, what can be described as a rather precarious time for justice and the rule of law in South Africa. We appear at a time when the rule of law remains in a dire state. I have often said it's in ICU. I think it still remains in a dire state. And despite our efforts to rebuild it, we continue to face strong headwinds. You are aware, Chair and honorable members, that there has been a significant amount of critical and negative reporting of late, relating in particular to the NPA in the criminal justice system. But before that, from the outset, Chair and honorable colleagues, we recognize and we want to thank the committee for the really robust way we are noticing that the committee is discharging its mandate of oversight and accountability in relation to all of us in the justice system. This is indeed a sign of a really vibrant and a vibrant constitutional democracy. Getting back to the negative reporting on the NPA, this has been particularly in the context of two matters for which the NPA has been heavily criticized. That's the extradition of the application for the extradition of the Gupta brothers, as well as the New Lane cases. That said, it would be most unfortunate for us to calibrate today's discussion through the lens of these two cases alone. Whilst these cases have indeed been a setback, and we are not taking this line down, we must really guard against the risk that we throw out the justice baby with the proverbial bathwater, so to speak. This will be in no one's interests, except perhaps those that are hoping to escape accountability. We have a solid criminal justice platform built on almost 30 years of experience and leading jurisprudence, to which the NPA has significantly contributed, especially in the last couple of years. Now is the time for us to build on this and not to break it down. Honorable Chair, honorable members, what we present to you today is an annual performance plan that builds on really 2 years of post-COVID investment in building a solid platform for the NPA. And why I say 2 years is because really the first year that the NDPP was appointed, it's only about a year and 4 months after the appointment of the NPA, of the NDPP, that the deputy national directors, 2 of them were appointed, and another year before the third one. So 16 months into the national director's term, nothing really had changed but the fact that there was a new national director. And it was not easy to do much in that, except to try to understand what was going on in a very complex organization. And so with the senior leadership having come on board at a time when we were hit by COVID, it really set us back in terms of really getting on this journey to rebuilding the NPA. And if one takes time and effort to delve into the detail of what the NPA has done to rebuild and the progress to date, from our initial commitment in the annual report of 2019-2020, where we said we were embarking on a journey to rebuild, as we called it, rebuilding an independent, professional, accountable and credible NPA. And then in 2020-21, our commitment to reclaiming our role as lawyers for the people. And then 2021-2022, where we committed to reaching solid ground to deliver justice, given the very shaky ground that we were on when I took office. And then finally, 2022-2023, we're really committing to reaching new heights, and that will become, we will present on that. So, there's really a lot that has been achieved post-COVID, and we're very confident that we are in the progress. We are in the process of really making a lot more progress that we will demonstrate, not just in terms of achieving our APP targets that we will present to you, but making really reaching new heights and building a fit for purpose NPA. To be sure, the path to get here has been challenging, and we certainly don't expect things to get easier, quite the opposite. But we remain confident that the strategy that we've developed in the NPA has placed us on the right path, and we are seeing the positive results with each passing year. In the interest of time, Honorable Chair, honorable members, we will be making a high-level presentation today. We've submitted our presentation to the committee in 2 parts. The current presentation, which we will take you through, and as I said, provides high-level information. And then there's another part which is submitted as like an annex, but it contains additional information for the committee members and more detail on some of the issues that I will present on at a high level. So we are now on slide 3. Do we have slide 3 on? Chairperson, members of the committee, this annual performance plan of 2023-2024 for the NPA is the last one in the current 5-year medium-term strategic framework cycle. The current I'm seeing something else on the slides. Can we get to slide 3? Thank you, Chair. Sorry for that. The current APP builds on our recent successes and also significant progress in relation to enrolling high-level and complex corruption matters. During our recent strategic planning sessions, we reaffirmed and we recognized that as the NPA, there is a lot more that we need to do. We need to be more efficient in our work. And moving forward in this particular year, we are focusing again on identified, prioritized, high impact driven prosecutions. We can't do everything, but we know what the country wants and we know what they want to see, and we know what kinds of prosecutions will enhance the credibility of the NPA and show that indeed accountability and the rule of law is on the road to recovery. We are selecting high impact cases for prosecutions, like we did last year with the ID in particular. We talked about the 9 seminal cases. We're not giving any numbers, but we certainly hope to bring many selected high impact prosecutions, but also importantly, asset recovery, particularly with regard to high level and complex corruption. But we're also looking at various other, to really put asset recovery into, almost the front and center of our work, and dealing more with asset recovery in terms of civil forfeiture, and also working with a range of partners, not just within government. DPCI is one of our key partners in asset recovery because they actually assist with identification and investigations. But also we are looking at engaging with the private sector in terms of NGOs that are working in various areas relating to accountability, to look at how we can really enhance asset recovery so that we can assist in the rebuilding of our country in a way that the communities will feel in a very tangible way. And so the APP also introduces 4 key strategic priorities as part of our efforts to future-proof the NPA. And these strategic priorities are set out in greater detail on the next slide. As I said, Honorable Chair, honorable members, the compliance APP measures that we have and that we will present to you, and you will notice that our performance in that regard has been increasing year on year. But we realize that simply complying with those targets, in as much as they're important, very important, but we have to have certain strategic initiatives that really support the building of the NPA into one that is, as I said, fit for purpose. And so the 4 strategic priorities that we decided on at our recent strategic review session will form the basis of our performance in the current financial period. And these 4 priorities have been entrenched into our operational plans and individual performance agreements of our staff, and their delivery will be monitored at EXCO and MANCO level. And so the 4 strategic priorities, I need to now just move to that slide if I can see it. Just a moment, Chair, let me just get onto that. Can someone help me with this slide? I need to just get, I think, yeah, but my lenses are not very good to see that. Chair, my apologies. I'm just trying to move to another slide. Can someone help me here, please? There you go. So, Chair, firstly, we are looking at, apologies for that, Honorable Chair, honorable members. First thing we are looking at is really prioritization. And so how does prioritization work as a matter of practice and policy? In order to ensure that we are not simply prosecuting in order to tick box numbers, but to really prosecute more smartly and strategically so that we, together with our partners, are able to really target offenders and strategic syndicate leaders, as well as their assets, as I had indicated, so that we can really have an impact on public safety and dealing with certain crime types, in particular, for example, sexual and gender-based violence and various types of organized crime. If we don't deal with these issues with particularly SAPs in a strategic way, we know that we are, the country is on a bit of a slippery slope as far as organized crime is concerned, and we have to really deal with this in a very strategic way. The other priorities that we're looking at, the 4 I mentioned, is Community Prosecutions Initiative. And it's really about strengthening our partnerships with a range of law enforcement partners, but importantly, with the communities. And it's really looking at long-term proactive solutions to crime irritants or community irritants that really have an impact on communities' feelings of safety. So this is more of a long-term strategic initiative, but importantly, we work with, as I said, all of the partners, but the communities must be part of the solution. And so this is one of our key strategic priorities moving forward in the next year. And then you see service delivery improvement, where we are, we want to be victim-centered, and we want to make sure that the people we served are satisfied with our levels of service. So we are implementing surveys, etc., to look at how we can be more responsive to our customers' needs. And finally, to amplify the NPA's voice and to strategically influence in the broader JCPS priority matters. And as I explained when I dealt with the first prioritization initiative, it's really to look at how we can move the dial with regard to dealing with some of these strategic issues at the JCPS level, in particular, organized crime, in particular, organized crime and asset recovery. So Chair, those are our 4 key strategic priorities. Chairperson and honorable members, in addition to the deliverables and outputs which are outlined in the APP, we are going to pursue these key activities in order to really enhance our ability to deliver for greater impact. And that is what's important. And so, as I said, we will in this period pursue a number of strategies and interventions, and we will build on what we have really done in the previous years in order to ensure that we can in fact reach greater heights in this current financial year. So I have talked to these, but let me just summarize some of these focus areas in a little more detail. I see I've talked about asset forfeiture, so I'm not going to deal with that anymore. Details about the strategy in regard to AFU is contained in the annex that I mentioned. With regard to organized crime, as I said, this is a significant threat to the South African people, to our economy, to our democratic institutions, and it really has a negative effect on all sectors of society and also on our international reputation. So the NPA has been collaboration with GTOC, that's a global initiative against transnational organized crime, in order to develop a very targeted, precise and focused NPA organized crime strategy. We do recognize that the success of any such strategy is highly dependent on collaboration with our JCPS partners, particularly the DPCI and crime intelligence. And so we are really working very closely with the DPCI to address these issues, but there are lots of challenges in this regard. South Africa's grey listing by FATF, moving forward this year, this is going to be a top priority for the NPA and our partners. The important thing is that this provides us with an opportunity to really reflect on our collective interventions and strategies to tackle and deal with money laundering and terror financing. And so we've been working very closely with law enforcement agencies to do really everything possible to ensure that South Africa is taken off the grey list as soon as possible, and therefore to reduce the costs of doing business in our country as one of the benefits. For its part, the NPA will really focus on identifying and enrolling cases that are linked to money laundering and terror financing. And we've put in place a mechanism in the NPA to ensure that with our partners, we are on track to meeting our obligations in terms of the FATF action plan. We're also working together with the Department of Justice on legislative reform to be considered by Parliament before it rises this year, to ensure that the investigating directorate within the NPA is established as a permanent identity, as the President announced in October 2022 in his response to Parliament on the recommendations of the State Capture Commission. Importantly, to establish a permanent ID with the requisite criminal investigative powers. And this will certainly allow the ID to be capacitated properly for us to recruit investigators, analysts permanently, and all of the specialized skills that we need to support the work of the ID and our prosecutors. We will continue to coordinate and monitor progress on complex corruption and asset forfeiture cases through the integrated task force, that is the NPA DPCI task force. We are also working on bringing in the FIC and the SIU on board to work within the framework of the task force. And I should say as well that they are very good projects in the context of dealing with money laundering, particularly the enablers of money laundering. For example, looking at estate agents, motor car dealerships, lawyers, the financial sector, and a whole range, accountants, a whole range of enablers of corruption and in particular state capture. Are we on slide 6, colleagues? Chairperson and members of the committee, as I mentioned in my introduction, our current APP builds on the gains that we have made over the past couple of years. And the key gains includes the following that are actually reflected on slide 6. I can say with absolute confidence that we have succeeded in returning the NPA to a period of institutional growth and stability. Considerable progress has been made since the inception with regard to the task force that I mentioned. The ID has declared 89 investigations. They've enrolled 32 cases involving 187 accused persons. The asset forfeiture unit has secured freezing or preservation orders to the value of 12.9 billion and recoveries to the value of 2.9 billion. And this includes the ABB landmark recovery. And we are certainly looking to ramp up recoveries from the corporate sector and companies in particular as we move forward. In the context of also looking at this in the context of our alternate dispute resolution mechanism to ensure that we bring back significant amounts of money to the country. Through the task force, as the SCCUs, that's the specialized commercial crime units in the NPA, working that are in all of the DPP areas, as well as the head office, but working very closely with the DPCI, has enrolled 78 cases involving 363 accused from what is the anti-corruption task team priority case list. We've expanded the Thuthuzela Care Center's footprint, and you will recall that we've maintained conviction rates of around 76%. We now have 62 Thuthuzela Care Centers, and for a long time we had 55, but in the past 2 years, we've actually added 7 more Thuthuzela Care Centers. Chair, before I move to the next slide, let us just pause and reflect for a moment. From the acknowledgement last year of the very good work that the NPA is doing, we even received praise from this committee. Overnight, there is a growing narrative that the NPA is failing. And what is the basis for this about turn? An inverted commas failed extradition. Well, it is a failed extradition, but one that the South African authorities, the NPA, could do nothing more about. And we have said a lot about that in the media. And hopefully the process is now understood, so that the people of South Africa understand that there's nothing more that we could have done about this. And the New Lane case, which is the subject of an appeal. So these are just two matters which has really overnight changed the narrative. And I'm not underplaying. I understand the impact of the New Lane matter. We are making an application for leave to appeal, and that legal process must take its course. And we are certainly going to look at, any lessons that we can take from this process. But firstly, let's deal with the appeal process and then decide on what more we can do in the NPA with regard to various issues. But the narrative that the NPA is failing is a dangerous and a flawed one. As these achievements that I have outlined demonstrate, we are making significant progress. And it is in a very difficult and sometimes toxic environment. And the work that the NPA has done, and really it's the people in the NPA, the motivated, the dedicated, and really committed staff that are also affected by these negative sentiments, because they have been working really, really hard, from prosecutors here in the head office in the ID to prosecutors across the country in far-flung rural areas that are working really hard to rebuild together with us as a collective, this institution. And we know that the work that we've done, in as much as there's a lot more to be done, is work that any prosecuting authority in the world would be proud of. And I want to say and thank the prosecutors of the NPA for their hard work. And we are going to work much harder, I can assure you, committee, honorable members of the committee and chair, that it's sometimes these really the good work, it flies under the radar of public attention, because perhaps negative work, negative news is what sells. But as I say, we understand the impact of this, and we know that we need to deal with the matters and look at how we can, in fact, improve. The next slide provides, further evidence of what we have achieved. And I'm going to quickly go through these. I'm mindful of time. Firstly, working with SAPS, the DNA, we were in a crisis with regard to DNA. And this has really been turned around. We've fast-tracked 31,266 DNA reports between October 2020 and April 2023. And this is an astronomical amount. And what we are doing with this, together with the SAPS, particularly in the field of sexual and gender-based violence, we've identified a number of serial rapists. And so we are looking at how we can actually target the serial rapists. And I realize I'm 25 minutes already, so I'm going to speed up a little bit because we need to get to our APP. We've also picked up the ball with regard to TRC matters. We've appointed senior counsel to review the measures that we've adopted to prosecute and to deal with TRC matters. And it's the first time that the NPA is really making progress on accountability for these cases. We brought in lots of new capacity in the organization, over 700 young professionals through our aspirant prosecutor program. And this was the biggest intake of aspirant prosecutors since we relaunched the program. These are all really important successes for, the people of our country and members of this community to really be aware of. And these successes need to be understood in the context of the huge limitations that the NPA is actually facing, and also in the limited mandate under which we operate. And we've got a slide on the NPA mandate, and we all understand this, but we just put this in to really make it very clear that the mandate of the NPA is very specific and limited. And that is really, we investigate within that's Murphy's Law. We prosecute, we do not investigate within the broader criminal justice, and except now with regard to the ID with its very limited powers as well. And so in essence, you can only be as strong as the broader criminal justice system, and a lot of work needs to happen in that space. But in our space, we are really trying to do the best that we can. And so, we are dealing with the powers for the ID, and I talked about that earlier, so I'm not going to talk about that further. And slide 9 actually deals with, in addition to the broader constitutional mandate, we must really remind ourselves about the ambitious commitments that the NPA has made in its current strategy, and you see them all there: increased feelings of safety, improved investor confidence, improved access to our services. And we are really working hard to try to achieve these high-level outcomes, as well as meeting our commitments to Parliament in terms of our APPs. And so these are really critical for the NPA in terms of becoming what the country wants us to be, a credible and high-performing NPA. We've got now we're on slide 10. Just very quickly, Chair, before I hand over to my colleagues to give you the gist of the APP presentation, I just want to show, the committee this slide, which basically speaks to what I mentioned in my opening. It shows you the upward trajectory of the NPA's performance over the past 3 years, from 50% in 2020, 2021 to 71, 2021, 22 to 75, 2022, 2023. And we are certainly hoping that trajectory, or we're certainly not just hoping, but we are going to do all we can to ensure that trajectory continues on that upward trend. At our Manco meeting last year, we actually, we were really, because of this upward performance that we've been seeing, I think we adopted the song as the management: "Ain't no stopping us now, we're on the move." You can Google it, it's a great song. But we want to show that we are, we're really determined to ensure that we continue moving up. And I think where are we now? Are we ready to actually, I was wanting to talk a little bit about the ID seminal cases that we enrolled last year, but it's a demonstration, and they are very high level cases that we are moving, but we will certainly engage with the criticism, as I said, that stems from the 2 cases, and take lessons in the process. I think I now hand over to Salome Baloy, who is the special director, our chief director, head of strategy, and she is going to take us through the APP presentation.
Before she proceeds, I would have hoped, NDPP, that you were going to address us on the failure of the NPA to submit responses that we had requested when we met with yourselves on the 25th of October last year. They were centered mostly around the 220 cases, the task force cases, and we agreed with yourselves that you are going to submit the responses in writing, because some of them had to deal with the issues relating to case numbers, and that has never happened.
I want to apologize for yourself and to the committee for this. Looking into that.
DPP, we can't hear you.
Am I muted now?
Yes. Yes.
Okay. Chair, you were very faint at the time. Can you please repeat that so that we can hear properly exactly what we failed to do or respond or reply to the committee on? I heard you say something about 200 cases in the task force. Can I get clarity on that?
No, I'm saying that we're expecting that you are going to address us on the failure on the part of the NPA to submit written responses based on the meeting we had on the 25th of October last year, when you were presenting your annual report. There were a number of questions we asked, especially on the cases around the Zondo report, the task force, the 220 cases. that you had identified, and we asked specific questions with cases and case numbers, and we agreed with ourselves that you are going to submit those responses in writing, and that never came through.
Chair, we do have figures. I apologize that we didn't respond formally to the committee, but we have been reporting progress to there's a team, a integrated team that's led by the presidency, where we are reporting fairly regularly in terms of the progress on the Zondo Commission cases. And we have that information readily available. If we can perhaps move on to the APP presentation, and I will get those figures and I will deal with it immediately after that. And we will also submit it to the committee, but I apologize that it wasn't submitted earlier, Chair. Chair, I can't hear you. Chair, I'm sorry, I can't hear you.
Well, I don't know if you can hear me, but I'm not able to hear you.
Morning members, morning NTPP. I think the chair has left the platform maybe due to network issues. Can you maybe take two? I'll try and connect with the chair quickly.
Thank you very much, Antonio.
Sorry, NTPP, I was kicked out by, I think it's because of load shedding.
I hear you, Chair. I was just saying that again, I'm not sure how much of my response you heard. But I asked that we've been reporting to a committee on the implementation of the Zondo Commission recommendation.
Your network is bad. I can't hear you properly.
Chair, is this better?
Yes, yes.
Okay, so I'm not sure how much you heard of what I said, but we have all the information available. We have been reporting to a team in the presidency on the implementation and progress, and we've made significant progress. I have all the information available here right now. We could do it after and I will send it in writing again. But may I ask, Chair, that we first, if you allow the APP presentation to continue, and then I'll be able to give the figures and also submit it in writing to the committee. But we will update the committee right now, if that's in order, Chair.
That's fine. That's fine.
Thank you, Chair. Salome Baloy, our Chief Director, Head of Strategy, will take you through the APP, Chair.
Thank you, NDPP. Good morning, Chair and esteemed honorable members of the Portfolio Committee. Chairperson, can you hear me? Chairperson,
Yes,
am I audible?
Yes, you are audible.
Okay, thank you. As the NDPP has alluded, I wish to take you through the 2023-2024 performance deliverables, which the NPA will be pursuing this year, over and above the already outlined strategic initiatives and priorities. Chairperson, at the outset, we would like to make a few points regarding our targets. As we all are aware that the NPA is part of a highly complex value chain. We cannot control all aspects affecting cases, which can therefore affect our performance. We have complicated, rather ambitious outcomes that speaks to your increased feelings of safety, improved investor confidence, and improved access to our services, which effectively deals with people's lives. And therefore, tinkering with our targets, that is increasing our numbers, can create perverse incentives, that is to choose easier cases that might have less impact just to meet the higher targets. Therefore, our targets are also ambitious, even if we might not achieve, or either we can achieve them at times. And we really do note the concerns that the committee has regarding reduction of targets. However, I wish to emphasize that the NPA chairperson has not reduced its performance targets for the 2023 and 2024 reporting period. We have maintained much of our performance targets over the MTF period. That is largely due to this further consideration that the NPA has a number of indicators linked to the conviction rates, which are sometimes questioned. However, these convictions speaks to the core function of prosecutors, the decision to take a matter to trial or not. And as we all are aware that prosecutions is not to seek convictions at all costs, but to ensure justice is done by assisting the court to derive at a just, fair, and correct judgment. Convictions rate is also an acceptable indicator that is internationally measured by many jurisdictions, although they measure it differently due to different legal systems. And our indicators are carefully considered and selected after a thorough analysis has been done, research and consultation through discussions, and we essentially then kept our indicators the way we have kept them. Slide 13. The following indicators in terms of slide 13, Chairperson, speaks to the fraud and corruption dealt with. Here, Chair, I wish to really just touch on the revised performance indicator that reads the number of state capture and complex commercial crime, complex corruption matters enrolled, which previously read the number of state capture matters enrolled. This, Chair, is an indicator which has been revised to reflect the collective mandate of the ID rather than its narrow interpretation, which was focusing in the main on the Zondo Commission cases. The next indicator as well that has changed in the APP reflects the number of prosecutions instituted involving money laundering charges, which previously was reading a number of cases finalized with a verdict involving money laundering. This indicator was reviewed, Chairperson, following the FATF evaluation, which actually then requires the number of prosecutions instituted to include various typologies that deals with professional enablers, money laundering networks, illicit flows of funds across borders, and third-party laundering. And the rest of the indicators are still as was reflected in the previous years. The slide 14, Chairperson, speaks to addressing the proceeds of crime, and these indicators are mainly the MTSF indicators, which have been retained accordingly because we are in our last year of the MTSF period. So we will be ensuring that we finalize those indicators and the targets as reflected. This next slide speaks to victim-centric services enhanced. And the indicators are also retained that speaks to the conviction rate in sexual offenses, number of witnesses. But however, I would also like to draw the attention of the committee to the change in the description of the indicator that reads the number of new Tutuzela care centers established. Previously, we used to have a total number of TCCs, which will then reflect a total number of those that has been established. But however, the performance that we are actually measuring is the new ones that we are establishing, which then the targets reach that we will be establishing two. However, as and when we report, we will then reflect the total number of all the indicators and all the Tutuzela care centers that have been established, which will then translate into 2023-2024 being 64 in total. And Chairperson, the next slide speaks to the issues on risk, the strategic risk profile that the leadership has identified through a risk assessment process. And 7 top risks were identified, and they are reflected on that slide. And these are the risks that we will be monitoring through our EXCO and MENCO on a quarterly basis. And Chairperson, thank you. This concludes my presentation before on the APP itself, and then we will take the presentation for the finance after this. Thank you.
Honorable Chair, honorable members, Hanika van Zyl will present. She's our Chief Director Finance, will present on the finance. Hanika.
Thank you, NDPP. Good morning, Honorable Chair and members. I'll quickly take you through the budget presentation. On the first slide of the budget presentation, you will see that we have overspent the previous financial year, the 2022-23 financial year, with an overall of 52 million at the end of the financial year. The 52 million overspending was as a result of 60 million in respect of compensation of employees. This is where we did the appointment of the aspirants and the implementation of the cost of living adjustments. This overspending of 60 million was done in consultation with the Department of Justice. So the overspending will be defrayed from the spendings within the overall vote. So of the environment, you won't see the 60 million anymore. Then we had a overspending in goods and services, which relates to overspending in the library subscription, witness fees, field services, and computer services. This overspending will also be environmented from our saving in the capital machinery and equipment line item. The next slide is just the breakdown of the 52 million per SIP program. And here you will see the bulk of the overspending was in the National Prosecuting Services, where we had an 80 million overspending, where the bulk of the aspirant prosecuting overspending lies. In the investigating directorate, we had a saving of 65 million. This amount was environmented also with the approval of National Treasury to defray some of the overspending within the overall SIP program. The next slide is an indication of the 1.3 million additional MTF budget that was allocated to the MPA. This slide is, I think, well known to everybody, and everybody has seen this. So we've just added it again. And then the next slide shows us how we will utilize the additional funding. Of the 1.3 million, we will use 134 million of this money will be used to increase capacity within the MPA, and the remainder of the additional funding will be used in goods and services for specified items as per the presentation. Then the next two slides is a little bit more detail on our donations in kind that we've received through the financial year. And I think that's the end of the presentation for finance. Thanks, NDPP.
Thank you, Hanika van Zyl and Salome Baloyi. Honorable Chair, just a few closing remarks. It was just recently that someone made a comment, isn't it a scandal that the NPA hasn't prosecuted a single person for state capture? And I just want to make it clear that this statement is not supported by the facts. And I will give you some of the figures now that you in fact asked for relating to the Zondo Commission. You know, the State Capture Commission finished its work and handed in the final report in June 2022. And the president responded to its recommendations in October, as I mentioned earlier. And while the commission was doing its work, the NPA was not sitting idly by waiting for the commission to finish its work. We were asked this question many times, and we did say we were actually doing what we can whilst we were waiting for the report. And then just to deal with the question that you raised, Honorable Chair, to say that in total, the investigating directorate there were 122 recommendations that in this report that are being dealt with by the ID. The DPCI and ID collaboration, there are 32 recommendations. The DPCI and the SCCU, Specialized Commercial Crime Unit in the NPA, are dealing with 43 recommendations, and IPID is dealing with 3 recommendations. Honorable Chair, honorable members, with regard to the ID recommendations, the 122, there are 20 matters that are in the intake process. So the ID is considering whether investigations should be authorized in those matters. Under investigation or asset recovery proceedings, there are 81 matters. The number of recommendations where matters have been enrolled in courts already is 20. There's one case where it's been decided there will be no prosecution, and that is the breakdown of the recommendations that are in the ID space. And then just to let the committee know that a number of recommendations are being dealt with by the DPCI working with the SCCU in the NPA. And those are 83 recommendations where 50 is, sorry, let me clarify, 50 of those are with the SCCU and 33 are the DPCI working with the ID. Number of cases in court with regard to these matters are 4, which actually relates to 18 recommendations. Number of cases under investigations, 13. Number of inquiries, that's how the DPCI works, 37. There are 3 matters that have been finalized in court. Number of persons arrested or have appeared in court are 26. Well, it's actually 19 natural persons and 7 juristic persons. And we've got details like the number of statements obtained, etc., which I don't think I'll burden this committee with, but those are that's the progress in terms of dealing with the Zondo Commission recommendations. But I will send that in writing to the committee as well immediately after this session, Honorable Chair, honorable members. We could go to slide 27. Are we there? It sets out what we're going to focus on this year, and what, Honorable Chair, honorable members, we need the committee's help with. We are going to continue to pursue impactful work through the ID, but as I mentioned earlier, we need the NPA amendment bill we need these amendments to go through as soon as possible, and certainly in this term, in order to establish the ID as a permanent entity with all the requisite criminal investigative powers. If we don't, the ID will not be able to do the work that we plan to do in the coming year. We will be able to move at the pace that is not ideal in the circumstances. That will be a game changer, and we will really be able to capacitate the ID, as I explained earlier, to deliver for impact. We actually, as I mentioned, we are looking at prioritization, and as the NDPP, my priority over the coming months will be to ensure that all of these cases are moving at moving with a huge sense of urgency. It's not like we haven't been, but we've really got to move a lot faster, and that they also have all of the necessary internal and external resources in order to be able to deliver for impact. And this is a logical outcome of the systematic processes we've put in place to deliver on the progress that I've reported on today. I've talked about organized crime. That's also going to be a focus for us. We have a capacity enhancement initiative with tailored interventions to make sure we have the right capacities and capabilities. Honorable Chair, honorable members, we know that we cannot succeed on our own, and we will continue to work with our partners in law enforcement, also with partners in civil society and the private sector. We have been solidifying partnerships with entities like the FIC and SIU. We have, in fact, prosecutors and investigators that are stationed at the FIC in order to deal with particularly money laundering matters with speed. And we are also working jointly to address the FATF recommendations. We've obtained the Minister of Finance's concurrence on the regulations for the Office of Ethics and Accountability in the NPA, the OEA, and we are now waiting for the Minister of Justice to approve the regulations so that this office can be formally established and capacitated, and which will contribute to enhancing our IPAC values. As we prepare for the next MTSF cycle, we are going to consult internally and externally to ensure that our targets are informed. The new targets that we set for the next 5 years are informed by good research. We appreciate the contributions of various civil organizations, some of which have engaged with this committee to ensure that our targets are properly crafted, and the upcoming review for the MTSF 2024-29 really affords the NPA an opportunity to strategically influence the broader JCPS agenda. And lastly, Honorable Chair, honorable members, we continue to collaborate with the Department of Justice to explore aspects relating to the NPA's independence in line with the President's response to the recommendations of the State Capture Commission last year. On behalf of the NPA, Honorable Chair, honorable members, I want to thank the committee for their time, and we are now available to take questions and comments. I thank you, Chair.
Thank you very much. Members, are there any questions? Honorable Breitenbach, Honorable Horn. Honorable Breitenbach, can you start?
Thank you, Honorable Chair, and good morning to everybody on the platform. Chairperson, let me begin by saying, that I acknowledge that the National Prosecuting Authority has a very big job. It's responsible for all the prosecutions in the country, and that includes not only the high-profile matters about which we are also concerned, but also the nuts and bolts matters of everyday prosecutions. And that's not to say that those are not important. Of course they are. Every single complainant in every single matter regards their case as the most important case because it is to them. And so while it is true that by far the majority of prosecutors go to court every day and do their very best to keep the wheels of justice turning, however excruciatingly slowly, those nuts and bolts cases are dealt with on a daily basis, and that's a big job. And so the prosecutors in the NPA must get credit for that. But that doesn't mean that they shouldn't be held to account for the big matters, the matters that grip the public's imagination, the matters that have cost us as a country a massive amount. And we all know what those matters are, the matters that were dealt with in the Zondo Commission, the Gupta's matter, the all the state capture matters, all the high-profile capturing of state-owned enterprises and the looting and stealing and corruption and racketeering that goes on a daily basis in those state-owned enterprises. Those are cases that capture the imagination of South Africa, that have destroyed our economy, have brought this country to its knees. And for those cases, unfortunately, we must also hold the NPA accountable, because it's also their job to do those. And in that respect, the progress is disappointing. And there's no other way of putting it.
Honorable Chair, we are losing Advocate Breitenbach. We are not able to hear.
That should make a whole lot of people very happy, but yes.
Honorable Breitenbach, just a bit. I think check your side, because I can hear her quite clearly this side. I think there might be a problem on your side, NTPP.
I can't hear the NTPP now, Chair.
We can't hear you, NTPP.
This is why I cut my speaker. Chair, can you hear me now?
Yeah, we can hear you.
Sorry, I was saying that I lost Advocate Breitenbach for about a minute, and yourself as well. I'm not sure what was said.
Honorable Breitenbach, can you just summarize what you said?
Well, that's a bit difficult, Chair. I said quite a lot.
Chair, just the last minute or so.
I'll try and remember what I said in the last minute or so, but it's quite difficult to do. So, credit to the NPA for the nuts and bolts matters, and I agree, and the NDPP will also agree that whenever I find the NPA having done well in a case, got a good conviction, even in a small matter, I regularly either send her a note, or I send the relevant prosecutor a note, or I send the relevant DPP a note to say, well done. We notice that you are doing these things. We notice that the smaller matters are being dealt with, and dealt with successfully and well. So, but that doesn't absolve them from prosecuting the big cases, the cases that have brought the egregious corruption, money laundering, racketeering, pure theft cases that have brought our country and our economy to its knees. And so we hold them accountable for those as well. And that progress is somewhat lacking. We have heard, watch the space, in the next 6 months, we're going to make all these arrests. We hear those things, and then very little happens. In December last year, there was a flurry of what was billed as high-profile arrests. They weren't really high-profile arrests. They were sort of semi-high-profile arrests. But an arrest is like, one swallow doesn't make a spring. An arrest is nothing. Arrest is a very baby step in a successful prosecution. Where are the prosecutions? Why are they not in court? Why are we not seeing people being tried? There are no cases on the go. Those are the things that bother us. Those are the things that are bothering South Africans, and that is destroying public confidence in the National Prosecuting Authority. So there's no point in saying that it's unfair for all the negative reporting, the NPA is making improvements, it's doing well. Of course, the National Director inherited what in Afrikaans could be called a bankrot boedel, and she had a lot of work to do to fix it, which she's had some time, let's face it. And so, I think it's not unreasonable to expect progress. And we expect progress. And we're not seeing enough of it. So South Africans, and I'm sure the rest of this committee, and certainly I, want to see high-profile prosecutions in court, not arrests, not watch the space in 6 months. People in court getting convicted and going to jail. If we can get the money back, so much the better. But South Africans want people to be held accountable. South Africans want to see that there are serious consequences for antisocial behavior. And we're not seeing that. And so South Africa will continue to be a failed state. South Africa will continue to be a state where the person with the biggest gun or the biggest wallet calls the tune. Because at the moment, no South African feels safe. I guarantee you that if you walked into the streets of any city in South Africa and spoke to the first 50 people you saw, you'd be very fortunate to find one who would tell you that they felt safe. They don't. Violence is out of control. Crime is out of control. Everybody's being ripped off around every corner, and there's no consequence for it. It's the NPA's job to do that, and they're not doing it sufficiently. So I'd like comment on that. Then the appeal of the New Lane matter, Chair, I'm really interested in this appeal. It's in fact, not an appeal yet. It's simply a leave to appeal, which is, sort of a maybe thing. But traditionally, Section 174 of the Criminal Procedure Act, a discharge after the state's case, because there's insufficient evidence upon which a reasonable court could convict, means that there is no appeal. It's a discretionary decision by the judge. And traditionally, there's no appeal. So I would be interested to learn on what basis the appeal is being brought and on what grounds. And I'm sure that's not a secret because the documents must be filed publicly. So I'd like to understand better this process of an appeal of a Section 174 discharge. Certainly, it's reviewable, but that's just a review normally dressed up as an appeal dressed up as a review, but I would be interested to hear how it's going to be done. Bearing in mind that the judge found that expert witnesses in the matter admitted to errors in the analysis of the financial network of the Guptas. How was this not picked up in time? When one takes a case of this magnitude to court, you work through that forensic report umpteen times. You check it, you recheck it. You have a forensic report on its own is nothing but hearsay evidence, and we all know that. It requires documents to back up the conclusions drawn, even from the expert. So where are those documents, and why weren't they there to back it up? And if they were, why were the errors not picked up? How come they were only picked up in court? That's not the place you want to pick up your errors. The judge found that the admissibility of documentary evidence, was not up to scratch. How is this possible that you get to court and then discover that you've got problems with the admissibility of documents? This is a high-profile case with a very experienced, specialized prosecutor. How does it happen? How do you get into court and then have admissibility problems? In a recent interview, Advocate Johnson said, and I quote, "When the prosecutors were preparing for court, we did have engagements. They didn't have any concerns, neither did I, because it was the same team that had been dealing with the matter from time to time, from the time that my predecessor was there. There wasn't anything glaring. It's only as the trial started that one realized, oops, we do have a challenge. We do have investigative shortcomings." Well, I don't actually know what to say about that. Because you have a run-up to a trial, a preparation to a trial. Your documents are gone through literally hundreds of times. How is it that only at the trial stage, the beginning of the trial stage, you pick up problems? I don't understand. I'd like an explanation. Then the NDPP correctly pointed out that the National Prosecuting Authority and prosecutors are heavily dependent on the police. Of course they are. Prosecutors take the product of the police's investigation to court. And we know that. That's how the system works. But in many matters, for many years now, and more particularly the types of matters that are high profile, of the type of New Lane, of the type of matters that are dealt with by the SCCU, and certainly the type of matters that will be dealt with by the ID, it's not really correct to say that the police do the investigations and the prosecutors do the prosecuting, because those investigations are prosecutor-led investigations. And if they're not, well, that explains a lot. Prosecutors interact with the investigators on a daily basis. And together as a team, they prepare a case for trial and prepare it for presentation. So it's not entirely true that prosecutors have nothing to do with investigation. They don't actually go out and do the investigation, I agree. But they certainly have a lot of input and control over how it's done. Or they should have. Then the National Director said quite a bit about organized crime being, you know, a big issue in South Africa. And of course, I agree. It's nationally, it is a big issue in South Africa. But that's not something new. It's been a big issue in South Africa for the last 20 years, maybe a little bigger now, but there are no protocols in place to deal with it. We're not winning that battle. And I hope there's not a recent discovery that organized crime is a problem, because it always has been. But in order to deal with organized crime, and again, I'm sure everybody knows this, you need crime intelligence. Crime intelligence is a police function. The police do not have anything remotely resembling a credible crime intelligence unit. So what's done about that? At what level is this thing being dealt with? And what is being put in place to establish a credible and effective and efficient and ethical crime intelligence unit within the police? Since the days of Richard Mbuli, and maybe even before, that capacity was destroyed. And I've not seen anything being built in its place, certainly not anything that will cut the mustard. Chair, then, with regards to the extradition matter, you know, the NPA has told us, and the minister has assured us, that they have done everything possible, that they've, as they put it, dotted all the I's and crossed all the T's. And until I get the documents from the one or the other, of course, I won't know that myself. So I must accept what they tell us. But then I need to understand what went wrong. I need to understand what, in the view of the NPA, happened here. Because we have a high-profile extradition. It is the thing that has to succeed. Everybody in the country's hopes are pinned on this one thing, and it's nothing but a shambles. And somebody's to blame, and at this point we don't know who. But bearing that in mind, I mean, there are now, you know, we're told that they can resubmit or they can appeal it. Well, you know, what would be the point unless we know where the Guptas are? Are they in the United Arab Emirates at all? Because if they're not, you know, don't bother. Waste of time, effort, and certainly of paper. So, you know, what is being done to determine where the Guptas are in the world? And what is being done to, once you determine that, then prepare an extradition application for whatever jurisdiction they may find themselves in. There are also troubling rumors circulating that appear to have some credibility that the Guptas were never arrested, that they were never held in custody. And I would like some comment on that. Is there anybody in the National Prosecuting Authority who can tell me, were they arrested? Were they held in custody? because I have it from reliable sources, more than one, that they were not. And those things are of great concern. So while I agree that the NPA has a very big job, and that their job doesn't only revolve around these important matters, there's no point in talking down these important matters. These important matters are important to South African citizens. They are the people to whom we all answer, the National Prosecuting Authority and this committee. And they want accountability and they want answers. And so I would like to hear from the NPA about those questions that I've asked. Thank you, Chair.
Thank you, Honorable Reitenbach. Honorable Horn.
Thank you, Chair, and good morning from my side. Yeah, Chair, I will try not to repeat what the Honorable Breitenbach has said, but maybe just to remind the NDPP of her own words when she appeared for the exact same briefing at this time last year, and when she in no uncertain terms informed the committee that she and the management of the NPA is ultimately very aware that the response to the findings of the Judicial Commission into inquiry will be what will define the credibility and the public trust in the NPA in the period to come. So at that stage, there was a clear understanding that this should be a top priority, and in that sense, maybe just to add my voice to the Honorable Breitenbach, and make one comment on the Nulani matter, and that is that it is therefore very concerning that if one reads through the comments of the judge in this matter, that with the greatest of respect, it would seem a basic due diligence exercise involving subject matter experts in evaluating what the NPA obviously at that stage believed to be credible and reliable evidence, would in all probability have shown it to not be credible and reliable, and short of exactly the let's say all of the substantive underlying matters that ultimately would enable admissibility. So it is a big concern, and I'm making these comments to really then focus, Chair, on the mammoth task that was always identified when Advocate Batoy was appointed, and that was the medium and long-term project of strengthening an NPA, which for a variety of reasons was by then a hollowed-out institution. And I want to ask a few specific questions on that issue, Chair. The first is that it was quite clear, and in the 2019-2020 annual report of the NPA, the NDPP admitted as much, that there were still prosecutors, and specifically senior prosecutors, which within the ranks of the NPA, which, and I quote, had been aiding and abetting state capture and corruption over the years. So at that stage, she asked for patience while there was a process that would unfold to investigate and deal with those matters. Then when Advocate Brunier resigned in December 2021, at a media briefing, when specifically the presence and continued influence of this cohort of unsuitable and unfit people within the senior ranks of the NPA was addressed with Advocate Batoy, she then said that this was an advanced stage. But yet, as we sit here now, middle of 2023, apart from 1 or 2 resignations of people who we believed were implicated by those comments in the 2019-2020 annual report, there's been no reports and no briefing to this committee as to whether that specific cancer in the NPA has ever been dealt with properly. And I think we must get answers now, because it's quite clear it must be addressed. And then there was the second issue, and the Honorable Breitenbach to an extent has referred to it already, around a clear realization that that middle layer of experience, whilst not yet necessarily being the most senior of prosecutors, but experience enough to start working in the regional courts with commercial crimes, that specific layer has more or less been depleted during the state capture years. And there was an undertaking that on the one hand, there would be identification of those who could be brought through the ranks. So we must ask what fruits have been delivered in that regard. But there was also an undertaking that with the additional budget that would be made available to the NPA, which has materialized, that there would be a recruitment drive to try and maybe even lure back some of those who must fill that layer. And we must ask, how is that going? Of course, it's good news that the aspirant prosecutors program is again up and running, and therefore, I mean, the NDPP is quite correct in saying that there is, of course, some good news stories. But Chair, the one thing that all of the negative news reports must inform is very focused questions and hopefully a focused effort on the part of the NPA to address with the strengthening of this institution, and this remain a worry. Chair, in respect of the Gupta extradition, I'm covered by the Honorable Breitenbach, and maybe we can also at this stage ask for an update on the Bushiri matter, in that the crimes of which this prophet, I see his real surname is not even Bushiri apparently, has been being accused of in South Africa are heinous crimes, some of it also rape, etc. And it remains a big concern that he's not yet back to answer to what he is accused of. Then if I can move on, the issue of the grey listing, Chair, remains a worry. I think from our side, it would seem that the report on the work that has been done and is being done at this stage, specifically also given some of the revelations of late, not necessarily even in South Africa, but through Al Jazeera specifically, must mean that mere action plans might ultimately not be enough for us to reverse grey listing. We've noted that the Deputy President has again also mentioned an integrated action plan in the NCOP, of which the NPA is playing an important role. On the one hand, it's a worry that there's nothing in the APP around this, but on the other hand, I think the more pertinent question is regarding specifically the revelations by Al Jazeera of late around the way in which South African banks are being used by organized crime and ultimately individuals and maybe even networks within those banks assisting criminal syndicates to park and ultimately money launder ill-gotten money. And this from an international television station. And I'm not saying this to accuse the NPA that it's somehow to blame for this. All I'm wanting to address with them and maybe get some responses is to say, it's becoming clearer by the day, as I said, that an ordinary action plan will not suffice. It will also hinge on whether the action plan is addressing the real ills, and whether the action plan will enable us, the law enforcement agencies of this country, which includes the NPA, to effectively deal with all of these crimes. So an update in this regard would or a bit more pertinent information, Chair, I think will ultimately go a long way to assist. Then, Chair, I have a few questions which really follows from a workshop that the committee had with the University of the Western Cape and Professor Munting and some colleagues. And that is around, firstly, and it goes to the heart to an extent of the way in which the NPA could assist stopping the regression of the capacity of the police by merely also performing its duties and functions when it comes to dealing with issues within the police, and that is the cases referred to it by IPIT, where through some research of the University of the Western Cape, it has become apparent that very few of those matters referred ultimately is being prosecuted, and ultimately still fewer ends in conviction. Yet it would seem that IPIT could play, along with then the NPA, could play a critical role in ensuring integrity in the ranks of the NPA, the South African Police Service, my apologies. So I think we need to ask for reasons why the IPIT referral seemingly is never dealt with as a matter of priority. And then in addition to that, the other, I think, important or worrying aspect was that the University of the Western Cape has indicated that according to its analysis of the way the NPA, by firstly the SAPS, but by extension the NPA, is unable to deal with regionalized problem areas. So it's quite clear, according to them, that for example, stock theft is a growing problem in areas that neighbors Lesotho. Yet it would seem that firstly the SAPS is not effectively dealing with it, but according to their analysis, a part of that problem ultimately would be that the NPA is not strategically looking at crime trends as well, and through analysis of crime trends, in engaging, guiding the police, and ultimately then assisting the criminal justice system as a whole. So that's but one example, but I think the general conclusion drawn by them is that the NPA is not proactively looking at crime trends in order to also assist the overall criminal justice system, or the administration of the criminal justice system. Then, Chair, in respect of the backlogs, it remains a big worry, I believe, to this committee, that ultimately, in between all of the role players, we can't seem to get a integrated and fully, a report that fully reflects the way in which the backlogs in our criminal courts are being dealt with. Closely linked to this is the reduction in court hours, which the standard answer is, of course, that not a single one of the role players or stakeholders could be held responsible for it. But I believe ultimately we can just do what we can do, and that is that if and when the NPA appears, we do the same with other stakeholders. We must ask what is being done to ensure that this trend is reversed about diminished court hours in as far as the NPA plays a role. And closely linked to this, Chair, is the issue of GBV-related crimes and specifically sexual crimes, where we are, as a committee, unfortunately not yet clear as to what enabled the massive turnaround within a space of 1 year, with a starting point that about 80% of the sexual offences cases were deemed to be on the backlog roll, and then it was brought down to 20%. And despite questions as to what percentage of that cases that were no longer on the backlog roll were withdrawn, and how many ultimately resulted in a verdict. And I believe we must also ask for very clear feedback in that regard. Thanks, Chair. For now, I'll pause at that point. If there is a second round, I might have further issues which I would want to interrogate. Thank you.
Thank you very much, Honorable Nivot Trochen.
Thank you, Chairperson. And good morning to everyone. Thank you for the presentation so far. While the question is still fresh in my mind from Honorable Horn, I would like to add to with regards to what is said with the sexual offences backlog and the decrease in that. I also want to know how many did not have DNA testing, or did the DNA testing take too long? So was it then thrown out of court? So I just want to know how many of those were related to DNA not being successfully tested or not done. Then I'm very happy to see the TCC numbers increased. The NDPP said from 55 to 62, so 7 extra TCCs. I'd like to know where are they, if they have been completed and if they are fully operational, those 7. I see the prior years or the next coming years, 4 will be added, so 2 per year. So where will they be, if I can get an indication on that? Then the NDPP said community initiative, the community working with the community, steps and different stakeholders. I'd like to know the community, the contact you make with the community. Is it successful, or is it still something that you are going to pursue, the engagement with community? Engaging with the community plays a very important role, and for the community to be involved, does the community take the NPA into their confidence in these engagements? Then I see nowhere or no target relating to cable theft. Prior, because of the cable theft, it also led to electricity, no electricity. So from the NPA, I'd like to know what, if it's not a target anymore, is it still a target? What is being done about the cable theft issue and the prosecutions in that? And then I'm not clear on the over expenditure. You said about 50 million or something over expenditure, and this will be covered by the NPA's savings. I'm not really clear. The savings, is it going to completely cover the over expenditure, or is it a part that's going to be covering that? So just more clarity on that. And then Honorable Horn covered me with regards to the grey listing. And I would appreciate an update, as his question was with regard to the grey listing. And on the last slide, I think it says organized crime. It talks about the organized crime strategy on the last slide. I want to know when will the strategy be complete? Has it already been completed? And then on slide 19, I see the ID. The E&E budget says 243.558 million, but the actual expenditure is only half of that. It's 178 something. So I just wanted to know why it's so much less. You know, when the actual money that is allocated was 243.58 million. Then on slide 13, the money laundering, you only put the baseline, but I don't know what the baseline is. What is the number of the baseline? So I'm just curious, okay, what are the numbers per year, and what does the baseline mean in terms of money laundering? And I think that is all that I have. Thank you so much, Chairperson, and thank you to the NDPP.
Thank you very much, Honorable Drogen. NDPP, just few issues on my side. One, does the NPA have a list of cases where it has effected high-profile arrest, and is it monitoring those cases? How many of those cases have started, and how many accused persons have already pleaded in those high-profile cases? How many of those cases have stand-alone money laundering charges that will result in a conviction? And then why is there no indicator in the APP to measure cases disposed through informal mediation processes? And then how many prosecutors have received training on alternative dispute resolution? In that workshop that we had that Honorable Horn alluded to, it was also said that the NPA policy directives are confidential and not publicly available. Can you confirm that? And if that is true, why is that so? And then why don't you have a target for community prosecutions? I'm concerned generally with the real increase of 1.07% for the asset forfeiture unit, looking at the role that it has to play in the fight against crime and corruption. I think that that increase is very, very low. If you can care to comment about that. And then, do you have an integrated action plan in your 2023-2024 APP to ensure increased investigation and prosecution of money laundering and complex cases? Those will be my questions on my side. Over to you, NDPP. Or should we NDPP give you 10 minutes, which will serve as a comfort break, so that you can also consult with your colleagues?
Thank you, Chair. That would be appreciated if we can. Thank you, Chair.
Okay. Thank you very much. Can we come back at 11:15?
You see what the problem is? So you mean like, oops, sorry. I will mute. Thank you.
Yes, we can come back at 11:15.
Thank you, Chair. Yes, Chair. I'm just about to do that. Thank you. Thank you very much, Chair, for that time to get ourselves organized. Chair, before my colleagues start with the specific responses, I just want to actually appreciate the comments by Honorable Breitenbach when she started, recognizing the nuts and bolts work of the NPA. The NPA deals with around 850,000 cases every year in a country that has one of the highest crime rates in the world. And so there's a very heavy workload in very complicated circumstances working within a system. So 99% of our cases are that, and they're hugely important for the people of this country, extremely important for the victims and survivors. But I appreciate that 1% of cases, maybe it's a bit more than a 1%, but those high-level, impactful cases that the country wants to see, and that the country will in fact measure the success of the NPA on, notwithstanding all of the good work that happens in other spaces, is what we are putting a very focus. It's not like it's a new thing. We did that last year, but we know we need to do more. And that is why this year I spoke earlier about sharpening our prioritization focus and making sure that these cases that the country wants to see are brought to court. And my colleagues will deal more with the actual state capture cases that have been enrolled to demonstrate that it's not like nothing has been done, recognizing a lot more needs to do. So I'm going to leave it at that. And I'll first ask Advocate Andrea Johnson to respond to matters that are in the ID space. If the colleagues just give me one moment, please.
Good morning, Honorable Chair, Honorable members, most especially Honorable Breitenbach and Honorable Horn. With regards the concerns and issues raised about the New Lane matter, or sometimes we err on the side of caution and call it the Nulani matter, it's one and the same. The response, Honorable Breitenbach, with regards the Section 174, matter was heard in the Superior Court. We are appealing on reservation questions of law. I'm not going to go into the detail, honorable members. Whilst the papers have been filed, I err on the side of caution in terms of respect to the acting honorable judge, and can only say that we are appealing on the issues of the applications of law in terms of the Section 174, the issues around common purpose, the issues around Section 204 witnesses, and issues around the admissibility of documentary evidence. And so whilst we are dealing with this, it is a leave to appeal application. Arguments and heads must still be filed, and delving beyond what I have responded to would take me into the merits of the matter and legal issues, which I'm unfortunately unable to do. But what I have to say, honorable members, is we take to heart the criticisms because they are concerns of the country that you voice. We have been considering all of the voices, not just yours, over the past 2 or 3 weeks. We have looked at how we can deal with them going forward. And there are lessons to be learned, and we will be embarking on that exercise. But what I would want to point out is, when I took office, there was a bit of review and revision to be done. And so the 9 seminal matters that the ID enrolled were not enrolled in the ordinary course of business. Matters were properly assessed. There were reviews done prior arrest. There were reviews and discussions of those matters with the project teams, the head of investigations, and the ID done after arrests. And we also have case review sessions, and we also then present our matters to the NPA's advisory panel, which is housed at the SCCU, but which also then with senior members of the NPA considers our matters going forward. So there are checks and balances that we have put in place going forward, and in terms of those matters. With regards to Gupta extradition, I know you've heard this many times. Let me just say it one more time. we have honestly, as the NPA, together with the central authority, which sits at DOJ, done everything we know we were supposed to do. We unfortunately, honorable members, cannot answer the questions raised, as we also await those questions which we have raised with the UAE through the central authority. And so, not wanting to sound evasive, we unfortunately do not have responses to those questions. And I'm sure that once questions have been answered, the relevant departments or parties will answer. Thank you, Honorable Chair.
Thank you, Advocate Johnson. Before Advocate du Plessis deals with some of the issues, just on the Gupta extradition matter, to deal with one specific question that was, were they ever in custody? All we can go by is on what was told to us. We were not allowed to go and see them physically. I was, in fact, informed by the Prosecutor General of Dubai informally that they were in custody. And so that is all we have. And you know, we can't take this any further. So, and on the issue of, yeah, I think on extraditions, yeah. Oh, and the other question by Advocate Breitenbach in terms of, you know, what were the issues? You know, what is sort of a suggestion and maybe an insinuation that maybe the NPA didn't get its papers right. It's very clear, and it's been that the UAE has told us why they have rejected the application. And we've said this publicly several times. It relates to the warrant of arrest, the fact that there were cancelled warrants, and we have tried to really explain why we provided the correct warrants, why we had to amend them, because the original warrants contains exchange control regulation contraventions, which is not recognized as an offense in the UAE. And so we had to issue new warrants of arrest, which we did, and which we expected would have been part of the papers. And it appears that was the first, from what they tell us, that was the first issue, and the judgment, that the parts of the judgment that we have seen. And the other issue was the fact that the UAE says that they have concurrent jurisdiction regarding money laundering matters, and that they could prosecute these matters themselves. These matters were never raised with us as issues that could put our application at risk, as they should have been, as cooperation requires them to do. So on the issue of money laundering, way back in 2019, Advocate Cronje and I met with colleagues in the UAE and squarely, in fact, put on the table that they could investigate money laundering charges and we could work with them on that. And there was no appetite for that. And now we get the judge saying they can investigate money laundering charges. So I'll leave it at that. It's a bit surprising. Advocate du Plessis will deal with some questions, Honourable Chair.
Honourable Chair, good morning, colleagues. I'm going to deal with some of the questions that were raised, but before I get to the specifics, I want to pick up on this point, and I think it's a really important point to focus on a bit, and that is this narrative or this perception that the NPA is not making any progress on state capture and high-profile corruption matters. Yes, of course, more progress needs to be made, and yes, the recent decisions or the recent outcomes of the cases in the two matters we've spoken about today have been a step backwards for us. But I think we do need to be a little bit more realistic in terms of the progress that has been made and how that should be recognized, not because we're trying to defend the NPA, but because it's a rule of law question. And I think the public, as much as we put this information out there, for some reason, it doesn't seem to be resonating. But let's just take one step back and think of, as a country, how few countries in the world that have the level of corruption we have would have, former ministers, sitting ministers, CEOs, former secretary generals of ruling parties constantly on trial, not just arrested, enrolled, matters in court, for the most high profile. And I would respectfully disagree with Honourable Breitenbach that these are not high profile matters. These are from I don't know how much more high profile we can go than that. I mean, these are really, based on the evidence that we followed, these are the most high profile matters in the country. And we have enrolled 34 of them through the ID alone. There have been 89 investigations declared. There are almost 200 accused in these matters that are on trial. And that's just the ID. We have a similar figures that we can give for the SCCU, although those are lower level matters, some of them. But I think just those statistics alone speak to the fact that there is progress being made against state capture cases. And the 9 seminal matters that were enrolled last year, I just don't think it's correct to say that those are not high profile, high impact matters that have harmed our country. And I think it's important just to get that balance right, in my view. And it's also, I know that it's a difficult environment to work in, but we mustn't forget that Andrea Johnson last year was voted by the readers of one of our top newspapers as being the person of the year, not because of any other reason, that I think the public did have confidence in the fact that she'd enrolled 9 seminal matters. So according to the public, at least at that point, there was a lot of confidence in NPA. And I just worry that we get into a self-fulfilling negative narrative that nothing's happening just because 2 cases didn't go the way we wanted them to go. That's not to make excuses. Of course, we have to learn lessons, but I thought I'll just open with those few remarks. I want to pick up on the questions that were asked first by Honourable Horn on the question of capacity. And that question's been very at the forefront of many discussions, especially in light of these recent cases. Does the NPA have the capacity to do what it needs to do? The answer to that is no, we don't. We've got excellent prosecutors. We've got experienced prosecutors, but we know what happened to the NPA. We know many prosecutors left. We know that a lot, when the Scorpions were shut down, went to the private sector. And we've been working hard to get these prosecutors and capacities back into the organization. We have appointed over 1,200 people into the organization in the last 2 years. We've just brought on 800 aspirant prosecutors. We are working extensively with partners, and we're bringing Section 38 senior counsel appointments in to bolster our capacity. But we certainly don't have all the capacity we need, and we are working very hard to rectify that. What we have to also recognize in the context of these kinds of cases, and I think Honourable Horn said that, a lot of colleagues had left the organization that had the experience to deal with it. You can't train prosecutors. I think Advocate Breitenbach made this point. You can't train prosecutors into this capacity. You have to get prosecutors to get the experience to move into the level of this capacity. So that's why we have to sometimes bring in external support. We have to bring our teams together, and we've developed or initiated what we've called an extensive capacity enhancement initiative, which firstly gave us a benchmark of what capacities we need in the specializations we need to prosecute high-level corruption and organized crime. The responses to that survey, where we assessed over 500 of our top specialist prosecutors, was rather surprising. The good news is that our prosecutors actually have really advanced demonstrated skills in terms of general prosecutorial capacity. The bad news is that they don't work in environments that are conducive to them to be able to do the work that they need to do. So that these are facilities problems, no toilets, no internet connections. And these are all things we're working with the Department of Justice on. So fixing the capacity problem is not just about training a few people. It's about fixing the environments that they work in so they can deliver on their mandates more effectively. So that's a key component of getting the capacity right. The next component of it is around specialization. And we, again, recognize we can't train people into the specialization. We have to mentor them. So we're adopting a coaching, a mentorship program. We are bringing back prosecutors that used to be in the NPA. We're bringing them back on contract to work with us, as we've done with the extradition matters. We are trying to get as many senior colleagues to take on these mentorship and coaching roles. But the problem, and unfortunately we have to admit it, there's no panacea to this problem overnight. It took 10 years to bring the criminal justice system to its knees. Colleagues, it's going to take more than 5, when 2 of those were during a global pandemic, to rebuild us to the level that we need in terms of the capacity. But please be assured that we are investing a huge amount of time and effort in coaching, mentoring, training, and bringing back the capacities we need. We have to also focus on the facilities and the environments that our prosecutors work in. The question around the ID and the budget, that's an important question. And we did get a lot of extra money for our response to state captured crimes. I'm very pleased to say that we, in the last year alone, have appointed 122 new colleagues into the ID. 138 appointments are in final or in advanced stages of being completed. And the ID's body count has moved from just under 100 in a year and a half ago to 215 now. And we're in the process of filling all those posts. So that's more than a 100% increase in capacity. But the challenge for the ID is that we know what its task is. It's mammoth. So maybe 215 is not even going to be enough. But the real challenge is something that the NDPP referred to, is that the capacity we need in the ID, we can't yet legally appoint, because we don't have the expanded mandate and the criminal investigative powers we need. We don't have the permanence that was included in the President's response to the Zonda report. So the real capacity we need, which is digital forensic analysts, data specialists, and most importantly, criminal investigators that don't report to the police, but report to the ID, that capacity we can't legally appoint yet. So as we're really hoping to get that legislation through, and obviously we're putting in place everything we need to put in place so we can move as fast as we can. I want to pick up two more issues, then I'll end. On the research that was presented by ACJR to the committee, we firstly welcome the committee's engagement with civil society on this. We thought it was a hugely important initiative. We hope you can continue doing it. We ourselves engaged extensively with ACJR and Professor Munting and others in the research they did, both on the magistrates' perceptions as well as on our reporting. And there were many important lessons that we've taken from that. And as we go into our next MTSF planning period, where we're going to be setting our new targets, we are taking a lot of their recommendations on board, and we're really hoping to improve on some areas. I just want to pick up on the two questions that were raised. The one about regional data and whether we present. We have all that information. It is included it's on our website. We do include summaries of it in our annual reports, but we've taken that advice on board. And in this year's annual report, we're providing more information on the regional challenges that we're facing. But that then speaks to, and we'll be disaggregating our data a lot more, not just on our website, but also in our report and in our annexes, to give Parliament and the public more information to exercise your oversight role more effectively. On the question of, are we looking at crime trends to inform our priorities? Of course we are. And that's why the focus that the NDPP put on prioritization, on community prosecution, that's all about that. We know that we have to take an 80-20 principle in our work. We can't prosecute our way out of the problems we face in this country. We have to prosecute based on the evidence, the crimes that are committing the most harm, not only at a national level, but at a community level. So community prosecution is all about that. We are constantly evaluating crime trends in the regions to make sure that we're putting our resources into the right areas, that we're focusing on the right crimes. And one example of that is our housebreaking project, which you'll find a lot of information on in the annex to the presentation we shared with you. We've given detailed information on both our prioritization projects and our housebreaking projects. And Honourable Horn, you'll see that exactly the points you're making is what we're engaging with extensively to make sure we respond to the challenges on the ground, not just that what we see in national headlines. There was a brief question asked about our expenditure and the over expenditure and whether we can absorb that in savings. As my colleague said, we're not going to absorb it. We're environmenting that in terms of the broader Department of Justice vote. So there is no over expenditure. It has been neutralized. That is something we do every single year because we are part of the same vote. It is something, in fact, that we plan for. So it didn't happen because of lack of budget planning. It was a discussion that we had with our colleagues in Justice, and that's a normal environment procedure that we go through every single year. And then the last point that was made by the chair that I'll pick up on is the allocation of the budget to the AFU. It's a point well made. The NDPP referred to the AFU strategy. We're calling it through a really ambitious phrasing of redesigning the AFU of the future. We've put a lot of detail in the annex, so please have a look at that in terms of where we're going with the AFU, and particularly its focus on organized crime and international recoveries. And we will most certainly be looking at the budget of the AFU as this new strategy kicks in. But I think it's also important to recognize that the AFU's budget is not the fact that there's that percentage of the budget allocated to AFU doesn't mean that the prioritization for asset forfeiture doesn't cut across the whole organization. An extensive amount of that work is happening within other units that work closely with the AFU. So I think those are all the questions for now. I don't think there were any others. I'll hand back to the NDPP. Thank you.
Thank you, Advocate du Plessis. Advocate de Kock, is your team ready? There are a number of areas that the NPS needs to cover. And I'll leave you to guide the process in terms of colleagues that will present.
Thank you very much, NDPP. We shall then continue to proceed with some of the additional responses. I'd like to start with the question that the chair has raised regarding the directives, the policy directives. We have policy, our prosecution policy that is published and that is publicly available.
So this is the important document that holds the prosecutors accountable for the work that they do. And this is also the document that is presented to Parliament. Then we have the policy directives. They are not published externally. They deal largely with internal processes. And these directions are for the work, the internal work of the prosecutors. So that is the reason why they are not published externally, except there are exceptions, Chair, where the legislation requires the directives to be published. Those are the sexual offences directives and child justice directives as examples. So where we are legislatively required to publish our directives, we do so. And then, of course, our policy, prosecution policy is also published. If I'd like then to respond to the questions regarding sexual offences and the tutezelas. We will ask the Special Director of the Sexual Offences and the Community Affairs Unit to respond to those questions first. Advocate Badi Karigamo, can you please proceed?
Good morning to the Honourable Chair and to the members as well as the colleagues that are on the platform today. First of all, let me respond to the question posed by the Honourable Nivo Drugen around the TCCs. It is correct that there were, as of until April, there were 62 operational Tutuzala care centres. I'd like to just inform you that the 63rd operational Tutuzala became operational on the 1st of May in Jozini in KZN. As to the additional TCCs that were added, just to note that they are located at Paarl, Uppington, Wynberg, Cradock, Nelspruit, Komani, and Dilokong. The Dilokong one being the one in Limpopo. That made up the 7 additional TCCs, which brought us to 62. But as I've just noted, the 63rd one has opened at Jozini in KZN. Then over the next 4 years, we have targets of adding 4 TCCs, or rather 2 years, we have the target of 4 additional TCCs. They have already been identified. The one will be at Mitchell's Plain. Jozini has in fact already opened, and that was is the +1 part of the +2 for this particular financial year. It's Jozini and Mitchell's Plain. Just to add that the TCC at Mitchell's Plain, the structure has already gone up. It is our first modular home structure, TCC, and we are hoping that in the very near future that it will be fully operational. And that, Honourable Chair and members, will then take us to the 64 for this financial year. But in addition, we have secured financial commitment for the 2 more sites at Odi and Brits through the private sector, as well as, in addition, Postmasburg and Mogwasi, both in the Northern Cape, and of course, Stellenbosch, which will be in the Western Cape again. Yeah. We have, Chair, honourable members, really targeted as the soccer unit and as the NPA, that we will ensure that there is an expansion, a rapid expansion of the TCC footprint in South Africa, because we do realize that if you look at the conviction rate of our cases going through the TCCs, we see a phenomenal increase of 16.1% between 2010 and 2023 of matters that go in through the TCCs. We would like all matters, all sexual offences, all GBV matters to go through the TCCs, because we do see the success of it. And hence the link through our rapid expansion as quickly as we can. Then also just to note that we're well aware that there are TCCs that need to be reaccommodated. Space has become an issue at some of the TCCs. The chair would note that these TCCs have been in operation, some of them since 2001. And so some of them need to be urgently replaced. And so the NPA is also looking at obtaining the necessary financial commitment in respect of that process as well. And then as to the backlog, the sexual offences backlog, just to note that one of the primary reasons for the rapid reduction of the sexual offences backlog has been the DNA task team that was created between the NPA and the police, specifically the Forensic Science Laboratory team of the police, to ensure prioritization of reports that were outstanding in respect of matters that were enrolled, and ensuring that those reports get to them as quickly as possible, which obviously reduced the number of cases that needed to be withdrawn or struck off the roll because of a lack of DNA. So that has had a huge impact. My colleague will take us through the more pertinent questions around the DNA. And so unless there's anything further, that is the extent of my response. Thank you very much.
Thank you very much, Advocate Karigamo. Chairperson, with your permission, I would then like Advocate Bani Karigamo's colleague, Advocate Pierce Smith, just to further expand on the DNA project, as well as the aspects raised on the community prosecutions. So I'll ask Advocate Smith to please proceed.
Good morning, Honourable Chair and Honourable members and colleagues on the platform. In relation to the DNA, as we currently stand, that would be for the month of May, by the 2nd of May of this financial year. We dealt with a number of 31,266 DNA reports as submitted from the Forensic Science Laboratory. I just need to note and place on record also that the colleagues need to remember that when we deal with such huge numbers, and specifically in the DNA sphere of expertise, not all necessarily will be reports that will be submitted in court because of the following. You deal with a number of reports that's finalized where you have a positive result, and in relation to the last submission, which was in May, we submitted 3,156 reports, of which 18.9% had a positive result. There's a negative result of negative reports as well, which will also assist the prosecution, at least to the extent that there's no scientific evidence to place the alleged offender on the scene. And that has been increased to 23.1% of finalization of reports with a specific result. However, it also needs to be noted that we picked up in the reports from the Forensic Science Laboratory that when we're talking about the DNA, that in some reports there is either insufficient or no DNA detected. Now, the no DNA detected was in the last bunch of reports of the 3,156, 1,148, which gives you a percentage of 36.4%. But that is improved by 28% from December 21, when that number stood at 64% due to specific interventions that we as the NPA soccer unit implemented with Forensic Science Laboratory unit and specifically the detectives of the SAPS unit to increase the number of DNA that will be submitted to the Forensic Science Laboratory. So in that regard, it's crucial to make a note of that, that when we deal with the DNA reports, there is a number of that does not necessarily going to assist the prosecution for the reasons as explained. So that covers the DNA reports. We've also, a part of that, identified possible reports that, as we call it, where it reflects the modus operandi of serial rapists. as a possibility, and that was also submitted to obviously the DPPs in the divisions. Also the possibility that will require in some instances the need for centralization when there needs to be that type of process being dealt with between the relevant DPPs in that regard. So that is the question in relation to the DNA and the project that we dealt with there. In relation to community prosecutions, honorable members, I'd like to explain that for community prosecutions, we currently have 25 sites that are identified nationally in all of the DPP divisions. All the divisions are represented in that regard. Some of them have 2, some of them have got 3 sites that they've identified with specifically liaison with stakeholders and specifically the communities to identify, as we refer to the community irritants, to put solutions in place in erasing those irritants that ultimately will contribute to a safer space environment for that particular area. Now, out of the 25 initiatives identified, 14 of them are specifically targeting gender-based violence-related sites, where either those issues are quite of a high priority focus in a particular area or in a particular community. So there we work with our colleagues to identify what those possible irritants are and put solutions in place. In addition, in relation to the stock theft question that came up previously, stock theft was also one of the initiatives identified in some of the divisions, specifically in the Mpumalanga division and the Northwest division, as a real issue for them in relation to where it samples the community growth in that regard. So in both those instances, we had certain successes. I will explain. In the Mpumalanga division, some of the kingpins were identified, dockets were investigated and prosecuted accordingly, and people were sentenced for long-term imprisonment in that regard, so-called to a removal of that irritant out of that particular community area. Same process is on its way in the Northwest division, where dockets were also opened and investigated, and prosecutions is also on its way in that regard. Also in relation to the community prosecution initiatives, in some instances, for instance, in the Western Cape, there were specifically initiatives identified where shebeens have been identified. As we all know, in some instances, they sell alcohol illegally. So there was a pertinent focus on those shebeens that are operating without licenses to stop those shebeens and close them down, which was also the position in the Gauteng division, Gauteng South, or Gauteng local division, where shebeens were closed down and a huge number of those liquor were confiscated. Prosecution, or rather investigations were opened and dockets investigated, and prosecutions will also follow in that regard. In addition to the current process and where we're standing with 25 sites, it's a responsibility as included in the work plan of the permanent senior public prosecutors that were appointed in the divisions. There are only 2 divisions that are short of that. That is the Northern Cape division and the Gauteng division, Pretoria, where we still need to do an appointment. Unfortunately, our colleague in the Western Cape division also recently resigned and got a position in another division. So in that regard, it must also be placed on record that the responsibilities of those colleagues are, they will act basically as a provincial coordinator for the community prosecution initiative in each division. They need to add an additional 3 initiatives or sites per division for the current financial year, which was included in their work plan, which they need to report on a quarterly basis for us at national office that's responsible for the national coordination to monitor and evaluate the progress of those sites. So colleagues, that will be the input from my side in relation to the DNA and the community prosecution initiative. I thank you.
Thank you very much, Advocate Smith. Honorable Chair, we are very excited about the Community Prosecutions Initiative, and all our directors of public prosecutions are keenly involved in that project. And so hopefully this will bring us much closer to our communities. That is what the idea is all about, so that we get a better understanding of the crimes that are impacting on communities, especially our vulnerable communities and our communities in our poverty-stricken areas. As far as just a follow-up on the stock theft in relation to the Free State, just to confirm that there are in fact 280 cases of stock theft currently in the Free State, on our Free State courts, which demonstrates again that those colleagues are working closely with the police in relation to those types of matters, and they are getting adequate attention. And some of those matters are in fact regarded as serious matters. So out of the 280, we have 102 cases in our regional courts to deal with stock theft. The next issue that we'd like to address is the question raised by Honorable Horn regarding the Bushiri matter. We felt it best that we would call from time to time some of our DPPs and special directors to respond. And in this instance, I've decided that Advocate Mzuniati, the DPP of Pretoria, should give a proper update to Parliament in relation to that matter. So I invite Advocate Mzuniati, with your permission, Chair, to please give us an update.
Thank you, Chair. Chair and the committee. With regard to the Bushiri matter, the extradition proceedings in the Magistrates Court in Lilongwe in Malawi commenced in 2020. And during those proceedings, amongst other things, in opposing his extradition, Mr. Bushiri and his wife, amongst others, insisted that the witnesses and the complainants in his matter should be in attendance in the court in Malawi to be cross-examined by his legal representatives. The DPP, the Director of Public Prosecutions in Malawi, in liaison with our office here, opposed that for obvious reasons, because we were arguing, or the argument was that witnesses should rather give evidence in the trial proper instead of giving evidence in an extradition hearing and thereafter be expected to give the same evidence before the trial court. However, the magistrate ordered that the witnesses should testify in South Africa before a competent court and be cross-examined by counsel for Mr. Bushiri. That was a judgment given by the Chief Resident Magistrate of Lilongwe on the 20th of August last year. Mr. Bushiri appealed this order of the Chief Resident Magistrate to the Malawi High Court, alleging that the magistrate had erred in several respects. He actually laid out 9 grounds in which he alleged that the magistrate had erred. After hearing the evidence, the High Court agreed with the magistrate that witnesses from South Africa should testify in the extradition hearing. However, he did emphasize that the witnesses that he is referring to are not the actual victims or the complainants in the matter. In his judgment that he gave on the 13th of February 2023, the magistrate held that the witnesses to an extradition hearing are those witnesses who will be able to answer to the extradition hearing that the fugitive offender is not accused of a political offense or offenses that have got a political character, that the fugitive offender is not being sought for prosecution on account of his race, religion, nationality, or political opinions, and that if the fugitive offender is surrendered to the requesting state, he will not be punished or be detained because of reason of his race, religion, nationality, or political opinions. The judge in the appeal court went on to point out that in an extradition hearing, it is the requesting state that is on trial, because it is that state that must pass the test and satisfy the court that it meets all the requirements that are set out under the Malawian extradition laws. He then clarified that the witnesses, therefore, who will go and testify in Malawi are representatives or agents of the requesting state who will be able to satisfy the court that their request meet all the requirements and be able to answer and are cross-examined on the issues that are raised in the hearing. As things currently stand now, the extradition hearing is scheduled in the Malawi, in the Lilongwe Magistrate Court on the 30th of May this year. And our High Commission office in Lilongwe has been advised by the DPP in Lilongwe that officials from the NPA and the DPCI, as well as the Central Authority, should be expected to be in attendance on that day to be cross-examined and give the evidence as set out in my earlier submission. As we speak, arrangements are currently underway to make arrangements for the attendance of those witnesses in the Malawi court. Thank you, Advocate Tukok, and thank you, Chair. That is the update on the Bushiri extradition.
Thank you very much for that update, Advocate Mziniachi. Chair and honorable members, just to proceed NDPP, there was a question regarding the SCCU and its capacity to address serious corruption. Just to indicate to the committee that in 2019, the establishment of the SCCU component within the MPA prosecutors throughout the country was 105 prosecutors. Since then, we have increased the numbers to the current number of 344 prosecutors collectively within the SCCU. What is also significant to note about the SCCU in relation to the backlog cases of the SCCU, as at 2020-2021, we managed a decrease of 22% in relation to the backlog cases on the SCCU court rolls. So there's certainly been an improvement in terms of the management of the matters, and also an improvement in terms of the number of prosecutors available to do the cases. Furthermore, we have, in collaboration with the DPPs in our divisions, ensured that the SCCU prosecutors are only seized with the most serious and complex work, and the rest of the work is managed through a deputy director in a DPP office, in consultation with the senior public prosecutors and the chief prosecutors, to ensure that that work is addressed in our normal regional courts. So we find that this is the best solution to the influx of all the commercial work that we have to do and the corruption work. And we balance the work between what is done within the SCCU environment and what is then done within our other court environment. The advantage, lastly, in terms of that approach, is that we also build the capacity of a certain of our regional court prosecutors to become the feeding ground for our specialized component within the SCCU. If I then can move to the general backlogs, there was a question regarding what is happening to backlogs currently, and are backlogs being managed on the court rolls. It is correct that this is a collective responsibility of all the role players within the criminal justice system, including the lawyers for the accused and the defense, to indicate that the backlogs are managed specifically by the judiciary. And in each of our divisions, there's a provincial efficiency committee meeting or enhancement committee meeting that is managed by the judge presidents of each of our divisions in the provinces. So the prosecution participates in those meetings with the other role players, and collectively attempts are made then to address the challenges that we are dealing with cases on the court rolls from a case flow management perspective. We feel that the backlogs have stabilized. In fact, in some instances, the backlogs are reducing. So if I can just give some indication of the stats, firstly, in the district courts, the backlog as at April 2021 stood at 28,000. The current backlog in our district court is 27,000 as at the end of March 23. So we have then seen that in fact there's been a reduction of the backlog cases in the district courts. In the regional courts, we see that in fact the figure has also improved from 24,000 in April 2021 to 23,000 as at March 2023. And similarly, in the high courts, the backlog as in April 2021 was 455, and currently the backlog in high court is 440. I want to say that from this financial year, the MPA will keep track of the impact of load shedding on the utilization of our courts. We have noticed a trend since about November last year of load shedding impacting negatively on the functioning of the courts, and this is increasing. So we will keep stats for each month of the courts that were in fact negatively impacted by load shedding, in the sense that the courts could not function. And as we know, if a court does not function, it means that cases will have to be postponed and witnesses will have to be recalled to future dates. This, we believe, will have a negative impact on our ability to finalize cases. So this year, honorable members will try and track that information carefully so that we can report to the committee on the next occasion. The last aspect I'd like to address, NDPP, is in fact the response to the grey listing of the country. The MPA is critically involved in partnership with all other state institutions responsible for various aspects of the money laundering system in the country. In this regard, we need to bear in mind that the National Treasury leads the process of the country's response to the grey listing, and that agencies within the financial sector are responsible to ensure that the regulation of our financial sector is improved. And so institutions like the FIC, the Financial Conduct Authority, the Reserve Bank have a critical role to play in terms of how we monitor and evaluate the efficacy of the system. And that is, in fact, what the FATF is designed to address. It's designed to look at how effective is our system as a whole in addressing issues that may arise where crime is committed within the system. So after the last engagement with the plenary of the FATF in February, South Africa were given certain strategic outcomes within which to address, and these are contained in 11 immediate outcomes that have been set out for the country. So I'm not going to go through all the detail of that, but the outcomes relevant to law enforcement is outcome 2, that speaks to the outgoing and incoming mutual legal assistance requests, that we ensure that our coordination of those requests are improved, which we are doing, and that we ensure that there's a timely follow-up in terms of our mutual legal assistance requests. So a lot of work has been done through the central authority. We've created an electronic data management system that is now in the testing phase within the central authority. And this will help all of us who are involved in mutual legal assistance and extradition work to track the progress of those matters and to give an accurate reflection in the further evaluation processes of the FATF in terms of the progress that we are making. In relation to the IOs, the immediate outcomes 3, 4, and 5, this speaks largely to the financial sector, as I've explained, and dealing with the cross-border movement of cash and funds, as well as beneficial ownership information. That was one outstanding area that South Africa's system did not have. The concern was that we did not have an accurate record of beneficial ownership of various corporate bodies and institutions. So all of that is being addressed through the recent legislative approvals that happened at the end of December and January. And a lot of work is now being done in relation to keeping accurate records of those beneficial ownership. In relation to the outcome number 6, this speaks to the question of financial intelligence reports that the South African Police Services, the DPCI, and other law enforcement agencies will get from the FIC, and that we need to improve or increase the number of those intelligence reports that are requested from the FIC. Further work is being done with the FIC in terms of a development of a system, an integrated system within which we can accurately capture the request in the main areas of money laundering investigations, and then how we track those investigations from the time that the intelligence information is given to us to the development of the investigative measures that are put in place by the police and other agencies, and to the decision that a prosecutor then has to take in terms of those individual matters. So that work is also work in progress, and a lot of developments are currently being done, including an electronic management system of those matters, so that once again, when we go back to the FATF in September, we are able to report better in relation to that. In relation to the next immediate outcome, which is outcome 7, here we need to demonstrate a sustained increase in the investigation and prosecution of serious and complex money laundering, in particular involving professional money laundering networks, enablers, and third-party money laundering. So in this regard, the MPA has allocated additional funding to the asset forfeiture unit, to the ID, and in fact to our specialized commercial crimes unit, as well as our witness protection program, to address some of the issues relevant to that work. We heard earlier that there are various initiatives currently underway within the ID and the AFU in collaboration with the FIC to identify further cases in this regard and for investigation. Our law enforcement agencies have developed an action plan, including key activities to be achieved and reporting in relation to that. And we have also developed indicators and activities in respect of money launderings in all of the APPs of our relevant business units. So the critical aspect to be noted here is that in compliance with the FATF obligations, in all of the plans of all of our critical agencies and of the prosecutors in our case and of investigators, all of the issues that have been identified to address money laundering will be dealt with specifically through the APPs and through the performance agreements of the prosecutors. These services, the DPCI is establishing a national and provincial anti-money laundering, counter-financing of terrorism task teams to accelerate the implementation of the work that needs to be done as far as this is concerned, as well as the DPCI and the SAPs are revisiting their own annual operational plans to ensure that the money laundering activities and indicators are contained in those plans. Ultimately, what we seek to achieve in terms of the increase of the money laundering investigations and prosecutions is that we will have sufficient and we'll be able to demonstrate sufficient examples of the types of cases that we have now done. So we are looking at the syndicated cases, we are looking at professional money laundering networks, we are looking at enablers, and we are looking at third-party money laundering. So the question around the baseline in relation to the APP of the MPA only speaks to the enrollment of money laundering cases for this financial year and going forward. This is a new baseline, and this addresses the concerns that the FATF have created. That is why we changed the baseline, and that is why it's called a baseline. In the previous years, we have measured finalized matters. So we have all of the finalized matters as matters that are currently within the information the MPA contains, and we have our cases that are currently on our court rolls. But we are starting a new baseline from an auditing point of view because the Auditor General will come and audit this information. And so that is why we call it a baseline. And so from this financial year, every new money laundering case that's been enrolled, at the time of plea, as soon as an accused pleads to the charges, that is where when it's recorded. And this year will then be the baseline. And in the next year, we will then continue with the information. So there will be an accurate reflection of the matters that are then enrolled in these different typologies that I've explained. And then we will be able to accurately also report to the FATF. So what we have done is we've indicated to the FATF from the law enforcement perspective that we will be reporting on the case progress at the end of September. So currently we are then in a phase where we are collecting all information that has been asked by the chair in relation to specific cases that is being collated. And so hopefully in the next period, at the end of September, when we do the evaluation with the joint group, we will be in a position to respond specifically on the work that we are doing. But we are confident that we have organized and aligned ourselves as the law enforcement agencies within the country to be able to address the money laundering specifically raised by the FATF. In the last meeting we went to with the FATF, they are provisionally happy with the plans that we have presented to them. And so hopefully at the end of the next period, which is by September, we will start to receive more positive responses in terms of the work that we are doing. As far as there are two other questions that were outstanding, ADRM training and the cable theft indicator. The ADRM training is an ongoing training within the MPA. We have been doing training for a number of years within the prosecution. and prosecutors are well versed in terms of this work. The training is also a component of our aspirant training program. And so all our new aspirants are inducted into the policy and the practice of ADRM within the prosecution. The last point to make about ADRM is that our policy indicates that ADRM is under the supervision of our senior public prosecutors, and where required, directors of public prosecutors oversee the work in the ADRM space. We don't have a specific indicator in relation to ADRM. ADRM is captured within our operational information as a finalized case. So it's counted with our finalized case. But if there's a need for us to identify how many matters were finalized by way of ADRM chair, we will be able to provide that information. The last issue regarding the cable theft indicator, this is in the indicators of the MPA, and particularly in the indicator of the prosecution services. So we have the cable theft indicator, but we also have an indicator dealing with essential infrastructure, which is really what we're trying to address under the cable theft indicator. And currently the overall conviction rate in relation to cable theft, essential infrastructure, is standing at 80%. So NDPP, I think from our side, those are the areas we wanted to cover. Thank you very much.
Thank you very much, Chair, and thank you, Advocate de Kock. I'm going to ask Advocate Rabaji Rastava to cover one or two questions. Thank you, Chair.
Thank you very much, Chairperson and honorable committee members. I'm going to deal with the issue around stock theft. If we look at just only 2 slides from the annexures to the report that was presented to the NDPP, on slide 16, we do make the point about the 4 strategic outcomes for the AFU asset recovery strategy, and community prosecutions be one of them. So the focus on stock theft under community prosecutions is to dial up on recoveries on instrumentalities of crime. So if you use your motor vehicle, your truck, to transport stolen stock, particularly the animals, will definitely seize that truck or motor vehicle. So, and then on slide 17, we do show the areas where stock theft is prevalent. So we've got 5 provinces, including the Free State and Northern Cape, where stock theft is prevalent.
Did you deal with IPID?
Just in future, we'll split up this slide on page 17 to show how we're dialing up on organized crime, but also then dialing up on community prosecutions, which for AFU is recoveries of instrumentalities, as I've indicated. On organized crime as a whole, we are dialing up. We're not starting from scratch. In fact, I've got a team that for the previous financial year, and I think this will come up in the annual performance plan when we present, we've already done 250 million freezing orders for organized crime. And back to stock theft. In the previous year, we have done almost 2 cases per month in terms of freezing the instrumentalities, as I've explained. And then we finalized half of the 21 that we've done in the previous financial year. So, and we've kept our stats for the last 10 years. And I think we can then deal with that when we present the annual performance plan. Thank you, NDPP and committee members.
Thank you very much, Advocate Rabaji Rastava. There are just a few, to wrap up on a few matters that colleagues have not touched on. Honorable Chair, honorable members, just to add to one or two of the issues that they've already discussed, just on the TCCs, as you heard from Advocate Bonnie Curry-Gamwell, that a lot of these, the expansion and the refurbishment is because of our collaborations with the private sector. Otherwise, we would not be able to move at the pace that we are. So we must appreciate and acknowledge what we've received and the support and also the funding from the private sector to actually really exponentially improve the TCC footprint, as well as refurbish the existing TCCs to ensure that across the country we receive the same, the standards are maintained. So we're also looking at to ensure that when victims and survivors do come to the TCCs, they get the same levels of service that we have committed to in the blueprint. So we are improving that all the time. And just to, on the other issue, just to pick up on the issue that Advocate Rabaji dealt with now on what we are increasingly doing with asset forfeiture is to look at how we can really ramp up our initiatives in AFU to deal with the instrumentalities of crime. So for example, she talked about stock theft. Yeah. And basically in the past, all we did is we prosecuted the person and the courts dealt with the matter and then they went off. Now we are saying, if the vehicle that you are using to steal the stock from, we will take the AFU will then apply to have that confiscated. So they must understand that this is also attempts to disrupt. For example, in fuel theft, we know that there are problems, organized crime, there's lots of challenges in terms of addressing it, but really to disrupt operations at the lower levels, we are looking at with the SAPs, once they do arrest people and if there are tankers on site, for example, to immediately engage the AFU to then freeze and seize instrumentalities of offense. So across a range of offenses, we are looking at how we can really ramp up our efforts to seize the instrumentalities and at least to create a disruptive impact on these offenses. Chair, I think there was a question on cable theft. It is in our, do we have the slide number? But I'll get back to that in a minute. Or was it responded? Oh, sorry, I missed that. I believe Advocate de Kock has responded to that. The issue of the disciplinary matters that were raised, just to say, sorry, before I move on to the disciplinary, still with organized crime, the strategy that the NPA is developing is at a very advanced stage, and we still will need to engage with our partners on this. But we hope that certainly from the NPA, in terms of the work that we are doing in the initial development of this plan, we will be finalizing that very shortly, and then of course engage with partners. Whilst I still, perhaps with organized crime, just to mention that there are many critical success factors in order to deal with organized crime. And one of them is crime intelligence. And I think we need to have, a clear understanding of what the challenges are with dealing with organized crime. And so that we can have the right responses. And so, the challenges with the intelligence in terms of proper analytical products to identify kingpins and then to actually follow the money. It's critically important that in our organized crime strategies, if we want to get to the kingpins, we have to look at financial investigations. It speaks for itself. And those are skills and expertise that the DPCI seriously needs to acquire. And so I think that's, we got to understand these are critical success factors. Also looking at corruption in our own spaces, in law enforcement, we've got to have people of the highest standards of integrity in these teams to ensure that we're able to deal with organized crime. So we are certainly looking at these issues, and we have in fact pushed for these matters to be on the JCPS agenda. The DG in the presidency has called for a strategy. No doubt the SAPs have a strategy, and I know that these are in the process of of being refined and presented, but unless the critical success factors and risks are dealt with, and that is where ministers and the executive needs to support law enforcement to get the necessary capabilities and capacities to deal with organized crime. We can have the best strategies, but we're not going to be able to be successful if those key issues are, those key competencies are lacking in the system. We have certainly from the NPA position raised this at the JCPS level, even with the minister, even with the president, in terms of the challenges in this area and the support from the executive to deal with these issues. With regard to the issue of cases proceeding, which is an issue, I'm not sure if Advocate de Kock dealt with that, but there are various reasons why, cases are delayed in the court process. The first step, certainly to indicate that the rule of law is working, is the arrest. But I agree completely that in order to have confidence in the rule of law, the entire system from arrest, it must show that, justice, we know justice delayed is justice denied. And so how do we make sure that the system works faster to ensure that cases get to a point where it's adjudicated and then finalized, and if necessary, sentences meted out. So there are various reasons why we can say there are these challenges in the system, but in the matters that have been enrolled on high-level corruption matters, a number of them are in the pre-trial processes. And one must understand that the Zondo Commission report was only finalized last year. The President's report to Parliament was in October last year. And so, October, November, December, January, February, March, April. We are now completed about 6 months effectively. And so, it's really, I think, to expect that cases are going to be finalized or proceeding to advanced stages in trial within 6 months, I think is unrealistic. But certainly we are doing our best to ensure that these cases do proceed through the system to ensure that there is confidence in the rule of law, as I indicated. The issue of, and I think the final issue, which I think I need to deal with, I just want to check before I get to the final issue, is really I suppose it actually relates to the number of cases in court. And I want to reiterate that we know what we have to do, and we know that a lot more needs to be done. But in order for us to really exponentially increase what we're doing, the ID has to get the powers, the permanence and the powers that it needs. Otherwise, we will continue to proceed at this pace that we also, it's not fast enough for us as those that are doing these cases. But I cannot really, overemphasize how important it is for the ID to be properly capacitated in order that it can do the work that it is supposed to do. So I'm really hoping that that process to get the ID permanent and the powers that it needs will move through the system, will move through Parliament very quickly, so that the Act is amended and that in the coming year, we'll be able to deliver on what the people of South Africa expect us to. I thank you, Chair. Chair, I'm not sure if matters that we have.
Yes, there's a question that was asked by Honorable Horn with regard to action that you might have taken or not have taken against certain prosecutors. And hear you.
My apologies, Chair, I did have that on my list of matters to address. In respect of these matters, there have been I've said this before, and I know these processes have been taking long. Certainly, it's not in the interest of the NPA, it's not in the interest of the staff members that these matters have not been finalized. But these are internal disciplinary processes, and there have been various challenges in this process. For example, I'll give one example that I can mention publicly, that the chairperson who was appointed regrettably passed away earlier this year. And so we were in the process of having a new chairperson appointed so that the disciplinary processes can continue. But we are really, certainly as the national director, I am extremely concerned that it takes this long, and certainly putting pressure to the extent that I can, because processes have to be followed to try to ensure that these matters are finalized as quickly as possible. Chair, that's as far as I can take it for now.
Members, are there any, I see Honorable Breitenbach, are there any further hands so that we can conclude? Can all people who want to speak raise their hands? Wants to make follow-ups? Honorable Breitenbach, you are the only one.
Thanks, Chair. Two questions that I forgot to ask. One has been partially answered, and then a follow-up, please. So the first question that I forgot to ask is, how involved and invested are the police, the South African Police Service, in the organized crime strategy? That would be important to ascertain if you want to properly deal with organized crime. And then the minister has told us, and the NDPP did touch on this now, the minister has told us some time ago that there's legislation in the pipeline to make the ID a permanent structure with proper resources, proper powers. What is the holdup with this? We haven't seen it. Where is it in the pipeline? Why is it not making any progress? And then the follow-up question, Chairs, on cable theft. I missed Advocate de Kock mentioned a percentage of cases. I missed that number, unfortunately. If you could just revisit that for me, and then perhaps just expand on the people that are being prosecuted for cable theft. Are they the small fry driving the getaway little bucky, selling the stuff at the chop shop? Or are there any kingpins that have been arrested? Because without arresting the kingpins, the little oaks are a dime a dozen. You catch one, there's another 10 waiting to take their place. Thank you, Chair.
Thank you very much, Honorable Breitenbach. National Director.
Chair, sorry, is that the only questions?
Yes.
Thank you, Chair. Advocate Koch, I'm not sure if there's anything you want to deal with. I can deal with.
Thank you very much for the questions, the follow-up questions. Just before I deal with those, there was a question in relation to IPID that we unfortunately did not respond to. The question spoke to our involvement with IPID and how we assist IPID to address those crimes that are allegedly committed by the police. We do have various meetings with the IPID. We've also participated in the IPID's National Strategic Planning meetings. And we also have arrangements in place in our provinces with the DPPs and through our senior public prosecutors work with IPID investigators on their matters. We also are looking at trying to create within the integrated justice system a reference for the IPID matters in the system so that it's easy to identify IPID cases on our court roll. So that's work in progress. And then lastly, in relation to priority investigations done by IPID, the invitation and the methodology that is employed, that those investigators engage with DPP officers and that prosecutors then assist the investigators with their prosecutor-guided investigation model in relation to those priority crimes that are committed by the police. So that's in relation to IPID. As far as the organized crime, the cable theft, we indicated the target is 80%. That for our convictions in relation to cable theft. And I did indicate that the cable theft indicator really speaks to essential infrastructure. And our approach in terms of essential infrastructure is not just to prosecute the people who commit the actual offenses of cutting the cables and stealing the cables, but in fact, to get to syndicates behind that. So there have been successes in that regard. And we have also authorized in some of our divisions racketeering prosecutions in relation to essential infrastructure. So this is an absolute priority for the MPA, and it's part of the crime types that have been identified in the revised MPA strategy to deal with organized crime. Critical infrastructure is one of the markets that we are addressing. So our approach must be that it will be holistic, that we have to look at all of the offenses that are committed, and that we have to look at the syndicates, and we have to ensure that there's asset recovery. So we have an integrated response. We have worked very closely with the DPCI and with the South African Police Services over the years to address organized crime. As far as the initiative that the MPA now has with developing a new organized crime strategy, further engagements will happen with the DPCI and with the South African Police Services. As we speak, we are arranging further meetings. We also come out of an ACTT strategic planning session with the DPCI and other critical role players, where we have agreed that the operational committee within the South African Police Services Act that oversees the work of the priority crimes in the country, that committee will be enhanced and restructured. And the focus areas of that committee will now be corruption, serious commercial, as well as organized crime. So we believe that by focusing the work in that particular way, quarterly reports will be able to be given to the leadership within the JCPS, and all the challenges that we may have within the organized crime space will be able to be addressed. We are also going to seek the activation of the ministerial committee within the DPCI legislation, so that we can ensure that there's sufficient resources and coordination is effective within the space. So I think those are all work in progress as we then continue to develop the strategy to address organized crime in our country. Lastly, I just want to make the point of the various task teams that have been set up to respond to the corruption and the crime in ESCOM, and all of this is also located in the prosecution within our organized crime capacity. So thank you. I think those are the issues from our side. Thank you, NDPP.
Thank you, Advocate de Kock. Honorable Chair, honorable members, those initiatives certainly are being put in place in order to try to deal with the issue of organized crime. I think to answer, I think it was, I'm not sure which honorable member's question about, was it Advocate Breitenbach about cable theft? Yes, you were the only one. Cable theft, in as much as there may be one or two racketeering matters authorized in the space, the reality is most of those arrested are indeed those at the lowest levels. And so it's something that we have to really move beyond. Otherwise, we can arrest them, thousands of them at that level. We will not be able to address this particular national priority. It's a national security issue. So there certainly needs to be a lot more done to ensure that the kingpins are identified, that there are proper, investigation plans that are multifaceted, bringing in asset forfeiture, following the money, which is critical. But as I said at the beginning, those critical success factors, if they are not in place, we can have all these structures, and the structures that Advocate de Kock said, they are really important in terms of trying to ensure coordination in this space. But again, without the capabilities, capacities, and that I mentioned at the beginning, and I'm not going to report, starting with identification of those critical kingpins, we are not going to be making an impact in this space at all. So that's really important. And on the issue of the legislation, where is it in the pipeline? We are still waiting for a revised draft from the Department of Justice. From the NPA side, we have certainly been pushing for this. I think the Department of Justice would be best placed to answer where that is in the pipeline, but I certainly hope it's about to pop out. Thank you very much, Honorable Chair, honorable members. Sorry, I'm reminded that there was one other question about organized crime and how invested and involved are the SAPs. I think I've explained all the challenges that we have, and I think perhaps that's best. That question should, I'm not trying to be dismissive, please forgive me, but I think our colleagues in SAPs would be best placed to answer that, but I think there's a lot of challenges. Thank you, Chair.
Thank you. You promised that you are going to answer those questions at the end of the presentation. The October questions, the 5th October questions.
Yeah, I actually dealt with after our strategy, our APP. I said I will deal with it after Ms. Baloy did the APP presentation, and then I did give all those statistics about what's happening in the ID space, the number of recommendations, investigations open, authorization, but I can certainly submit it in writing as well, but I'm not sure whether the chair missed that, but it was dealt with. Does the chair want me to repeat them, Chair?
No, maybe I should try and get some of those questions, because they were quite specific, they were not general. Maybe you can now respond to them latest Tuesday next week.
Okay. Certainly, Chair, we will do that.
Let me just check. With cases, how many of the 220 persons or entities recommended for prosecution by the Zondo Commission are currently being dealt with by the NPA task force? Of the 220, how many have been arrested and brought before court? Then of the 65 I choose enrolled for prosecutions in 20 cases, how many were on the list of the 220 persons recommended for prosecutions? Of the 27 cases recommended by the Zondo Commission for recovery of assets, how many were being dealt with by the AFU? And how many had preservation orders? How many had been forfeited to the state? Could the NPA in writing provide us with a list of case numbers and values involved and identify the corrupt contracts or the bribes that the order related to? You are muted.
My apologies, Chair. A lot of that information is, and I must apologize that it wasn't sent directly to you. A lot of that information is being sent, is it monthly, quarterly? Quarterly to the coordinating team in the presidency that is coordinating the response to the Zondo Commission recommendations. And of course, that is presented to Parliament through that process. But I accept that this was requested specifically from the NPA separately. We have the information and we will provide them to you by Tuesday, Honorable Chair, and to the committee.
No, thank you very much, NDPP, and to your team for spending part of the day with us. We hope to see you again in October.
We always look forward to that, Chair.
When we deal with the annual reports, but we will see you before that for the TRC cases. You know that we have a standing appointment with yourselves with regards to that. But thank you very much to all of you for gracing us with your presence.
Thank you very much, Honorable Chair, honorable members. We appreciate these engagements. We appreciate your guidance and support. It's really important that there is robust engagements, and where the NPA is not, is not reaching that point where, where people want it to be in a sense, and where there are these perceptions that the NPA is not doing its work, we expect that Parliament will raise this with us. And so we appreciate that. We will certainly try to do a lot better. But I want to assure the committee that that upward trajectory of the NPA will continue, and that not only will you see an improvement in our performance, but those high impact cases are going to be coming to court. I hope the directors of public prosecutions are all on this call. I have given them the marching orders, and the ID is certainly here, Advocate Kopp. They know very well what's expected of the NPA in order to show that we are making impact, and we will certainly deliver in the coming months and in the coming year. I thank you, Honorable Chair and members.
Thank you very much, NTPP, and to your team. Members, the time is 1:45. SIU has been with us for some time. Can we take a 15-minute break and start exactly at 1?
Thank you,
Is that in order?
Yes, yes, please, Chair.
Thank you.
I'm ready, Honorable Chair.
You are welcome, you and your team, and you are welcome.
Thank you.
It's good to have you on Friday afternoon.
That's fine. It's fine. No problem at all. Yeah.
No, thank you very much. Thank you.
Thank you.
The floor is yours.
Thank you, Honorable Chair. We thought we could probably just get an indication of the average time we have so that we don't go beyond the expected time. Hello?
You are putting me on the spot now because I did not do the same with the NPA.
Oh, okay, okay. No
so I don't want to be seen to be discriminated.
Okay, no problem at all.
You'll just be reasonable.
Thank you. Thank you. Thank you, Honorable Chair. Okay, no problem at all. Thank you. All right, we'll really try to do our best so that we don't really spend too much time. Honorable Chair and honorable members of the Portfolio Committee, thank you very much for the opportunity to present the SIU APP for the financial year 2023-2024. I'm joined by all the EXCO members at SIU. I'm going to ask Mr. Lekgetho, who's be assisting with the presentation, just please to project it, Mr. Lekgetho. Mr. Lekgetho, please. Mr. Lekgetho, are you there? Okay, there.
Thanks,
Thank you, Mr. Lekgetho. You can go to the next slide. Honorable Chair and honorable members, this is the presentation outline. We'll cover our mandate, strategic focus, and of course the performance measures and the targets. And we do cover the enablement functions, specifically on the financial information, human capital, and we do also inform the honorable committee members on the international relations focus that the SIU is involved in, and of course the future focus areas. Next slide, sir.
Sorry, Advocate Mutibi, maybe you can jump the mandate.
Okay, thank you. Thank you, Honorable Chair. It's covered on pages 12 to 17 of the APP. Mr. Lekgetho, you can go perhaps a focus on slide 6. Slide 6, without going into details of it, Honorable Chair and honorable members. This was a very important judgment that was handed down by the Constitutional Court in the Leather case. This emanated from the PPE investigations, specifically in Gauteng, where we took matters to the special tribunal for contracts to be cancelled, set aside, and we also done asset freeze and forfeitures. So the litigants there challenged the jurisdiction of the special tribunal. They went to the Supreme Court of Appeal, they failed, and they went up to the Constitutional Court. So the long and the short is that we are pleased that the Constitutional Court has now affirmed the powers of the special tribunal. This would really have had the effect of really slowing down our recovery process. So we defended the matter, and it was ruled. Of course, they said, no, the special tribunal is not a court, but we've never sought to call it a court, really, except that there's reference to Constitutional Court provisions, but it is a special tribunal, and it's got the mandate now to adjudicate on the legality of contracts, of procurement, and so on. So we are glad about that. We are going to see now an upward trajectory because it slowed down the special tribunal in this regard. And now the role is going through since the judgment in March. The next slide. Slide 7 really just gives our analysis of the impact of the judgment on the work of the SIU. In a sense, at the last point there, number 6, we are saying certainly the special tribunal powers will now increase the outcome of the recovery litigation substantially. So we are really pleased about that, Honorable Chair and Honorable Members. Now that takes me to the next slide, which shows the current picture of the matters that are in the special tribunal and in the high courts. These are the contract values of the cases that are in the both special tribunal and the high court. Now, in the middle is really cases in the special tribunal. It includes matters on the left-hand side, specifically COVID-19 matters. So given the Constitutional Court judgment, we are going to see now those matters really moving speedier. On the High Court side, those cases, if we really articulate and give the list, you'll see that there's matters that range, up to like 4, 5, 6 years ago, which really is becoming a matter of concern, and we are reaching out to the judge presidents in that regard to ensure that there's processes in place to speed up those cases. Thank you, Mr. Alkheto. Strategic focus area, Honorable Chair and Honorable Members. Those you can find in the details thereof in pages 19 to 31 of the APP. The slide that is shown, slide number 10, really just shows that after we had done the strategic review as the senior management at SIU, including provincial heads and other senior managers, the vision and the mission remained unchanged. And the values also remained unchanged because we believe that they are still relevant, integrity being at the center of what we do, and of course the others. So each and every SIU member is expected to live these values as we drive towards our vision. Next slide. Just in brief, we've presented this before to the Honorable Committee, but we want to really just indicate that after we've done the strategic review, we believed that these focus areas remained relevant. In particular, number 1, the turnaround times of investigations. This remains top of mind because it is the expectation of the public and of course the Honorable Committee to really speed up our investigations and produce outcomes that are expected. Number 2, we monitor the implementation of the SIU referrals and consequence management. On the right-hand side is really just some of the progress that we have made. And number 3, implementing targeted prevention and the awareness campaigns. This is also covered in the presentation later on. And then, of course, number 4, making systemic recommendations. This is really the important part of our mandate, that as we investigate and make findings, we recommend to the state institutions to improve the administration, and we work with them so that we can monitor that. Number 5, implementing corruption, maladministration, and malpractice data analytics. This is to contribute to corruption prevention framework, and we do cover it in the next slides. Now, next slide, please. Implementation of measures to accelerate civil litigation. We are pleased again that the later Constitutional Court judgment will give impetus to this strategic focus. Number 7, the funding model of SIU. There are engagements with Treasury that are really ongoing, but the Treasury has said to us that there's no need currently to change the funding model. What we should do is to change the debt that is owing to SIU. And in the finance part of our presentation, we are presenting to the Honorable Committee the progress we have made in recovering the debt. Improving communications and stakeholders engagement, communicating our outcomes. We've got a strategy run by the communications team that is really geared towards informing the public of our outcomes. And of course, number 9, the SIU governance remains key as we drive towards our business. Introducing a new organizational individual performance management system. This we continue to monitor. We have implemented it. Every employee in SIU has got a performance management system now. Honorable Chair and honorable members would recall that this has really been on the table for a while. We've agreed with the unions. Everyone has got a performance management agreement, and we are continuing to monitor that. At the last strategy session, we agreed that we should reintroduce the Enterprise Program Management Office, which we are underway doing, and the digitalization of the environment driven by the Chief Information Officer, of course, business development, and just general ensuring that we keep SIU as the employer of choice. Number 14, driving the key employee value proposition. And our Chief Human Capital will present in the human capital part. We will not really go into detail because the Honorable Committee is familiar with our programs. We use Program 1, which is administration, to deliver on our strategy. Program 2, which is the core business, investigations and legal counsel. Of course, the core business is also supported by Program 3, which is now the prevention part, systemic improvements around the market data analytics and prevention. Next slide. SIU operational framework, again, without going into detail, of course, it really just says we are investigation driven as an investigating unit, and we produce, of course, the outcomes based on the civil litigation and the referrals that we make for disciplinary action and for prosecution, and of course the reporting either to other regulatory authorities, but in the main, the reports that are made to the president once the investigations are completed. The next slide really just, again, streamlines now all of those outcomes which the Honorable Committee is familiar with, the civil litigation part, the disciplinary processes coming out of the investigations, NPA referrals, and we'll come back to the NPA referrals in terms of reference to the MOU that we have with NPA, and of course the other referrals to the relevant regulatory authorities. Something that we are pursuing now vigorously is that the private companies that are found to be in the wrong as they do business with government, that National Treasury and state institutions should blacklist them. And we continue to follow on that. As we have done now, our strategy and this APP, we looked at the external environment, which is expected when you conduct strategy session. Without going into detail, we've really determined that the trend is indicating that corruption is really still, a worrying factor worldwide in the continent. And on the left-hand side, we've looked at the corruption perception index that's driven by Transparency International. We have seen there that South Africa continues really to stagnate in terms of scoring. And on the yellow part is the one that was done by the local chapter of the Transparency International in South Africa, which is Corruption Watch. Again, it shows areas and the areas where we should really see the trends of improving of corruption and maladministration and fraud. And those trends, Honorable Chair and Honorable Members, they really align with our internal environment assessment. If you go to the next slide. The next slide, please. This is the some of the analysis that we've done internally. And as you can see there, we're starting with the number of allegations referred to SIU. All of the allegations are assessed as required by the APP. We look at all of them, and as you can see there, that for purposes of this presentation, we wanted to give a global picture to the Honorable Committee from 2018, 2019, 19, 20, 2021, 21, 22, and 22, 23. The bar charts on 2021, 22, 21, 22 really shows an increase, a spike in the allegations, but that is really attributable to the COVID-19 many allegations that we received. As you can see now, in 2022-23, we are beginning to see the numbers go down, but it's still quite a high number. So we thought we could give that picture to the Honorable Committee. The next picture we are giving is the whistleblower referrals in terms of the nature of the corruption, maladministration, fraud, bribery that we are receiving. And of course, as we now go in and motivate for the proclamations, we've got a division in SIU that does this. And as you can see, it really aligns with that external environment where we have seen, and it guides us in terms of where do we have to focus in terms of really resources, except to say that every proclamation that is issued requires appropriate attention, but this ultimately should give us a view on whether any of the categories are going down as we produce the results. Now, Honorable Chair and Honorable Members, on this slide, a related aspect is the whistleblower protection program, which of course we have reported before the Department of Justice is driving. We would like to ensure that when whistleblowers make these referrals, they can also feel that there is a protection program wherein if they are threatened, they could reach out to us as law enforcement agencies and ensure that they are protected. We really look forward to the outcome of that review of the program and ensure that the whistleblowers are protected. The next slide, continuation of the internal trends. Really, we have seen an upward performance trajectory by SIU, and this really it can be attributable to the commitment of the SIU members, and we have seen the results. This one really shows a three-year view, 1920, 2021, and 21-22, where we are seeing 100% performance on 21-22. Next slide really just shows Mr. Lekgetho. It still continues to show a picture to the Honorable Committee of the upward trajectory of performance of SIU. This is the comparison of 2021 and 21-22 financial year, which the committee has seen as we were presenting our annual reports. It's really just to indicate what the performance trajectory is about. We have also indicated the SIU path of improvement, because we need to ensure that we improve continuously. So as we speak at the moment, we have really just done 21-22, and we have realized that we have optimized our operations. Now, getting into 22-23, it was to maximize. And all these strategies and APPs would include all the elements that would assist us to maximize business outcomes. And that's why we continue now to see that trajectory going up. Of course, going forward to 24-25, we want to see service excellence. And now, as we work with the overall JCPS, we would like to see that as we excel, does this now result in the impact that the public is looking for in the reduction of the incidences of corruption? And of course, going forward, would like to produce a world-class business operation. Next slide. Honorable Chair and honorable members, the next slides, and will not really go very much in detail on them, except to say that SIU is really going, amongst others, in line with Program 3, going to really increase the momentum in ensuring that we play a role in the prevention of corruption. Now, this vulnerable sector risk management approach, Mr. Lokgetho, if you can slide through. This one ensures that we execute our function under the task team, the anti-corruption task team, and doing so, we then implement the national anti-corruption strategy that was adopted by Cabinet. And in particular, Pillar 6 of that strategy, which enjoins the whole of society approach. Now, this part of corruption vulnerable sector risk assessment takes that into account, and SIU has been mandated by ACTT, and that's why we've included it in our APP so that we are measured on that. So this slide really just says we have used the collaborative approach with other stakeholders in the ACTT. We have benchmarked with G20 anti-corruption working group, and we looked at the Auditor General outcomes as well, and also, of course, reports coming from other Chapter 9 institutions. So we've done a high-level risk assessment, and we've used the open data sources from other stakeholders. Now, the next slide should show the results of the risk assessment. This risk assessment, everyone was involved in ACTT. All these sectors should really, actually receive prioritization, but it's really a matter of saying, how is it that we now spread the resources? We've started now with the pilot in the health sector and the local government and infrastructure build. So those are the sector approach in dealing with risk that we are driving. So we collaborate and coordinate all the sectors, all the stakeholders in the sector. And we will show the Honorable Committee in the next slide. We particularly focus on the health sector. In doing the risk assessment, we took various factors into account, and this is what really that this slide is saying to the Honorable Committee. We look at various factors without going through them into detail. Now, a blueprint of the sector approach is the health sector approach. In this health sector, we took every stakeholder, and a health sector anti-corruption forum was established, and the president launched that forum in 2019 already. So as we speak today, we have commenced with a process to measure the effectiveness of this forum. But the methodology that we followed in this, we included the National Department of Health, the ACTT stakeholders, and all other members or stakeholders in this sector, be it the regulators in the environment, civil society, and so on. So the next slide really just shows the corruption exposures amongst others that we picked up in this sector. You would see there that fictitious claims related to doctor negligence, medical aid fraud, bogus doctors, and so on. So once we've done this, there's then a process to really determine what are the root causes. And that's the next slide. Some of the root causes of the corruption in this space, we've found a lot of collusion, a lack of effective consequence management, weak processes, conflict of interest is abound, particularly in the what's called RWAPs, remuneration outside of official hours by doctors. So these are the root causes. As I indicated, we made a presentation, Honorable Chair and Honorable Members, to the Presidential Health Summit that was held last week. And it was attended by various stakeholders. This approach by government of sector approach has been overwhelmingly welcomed. So what we need to do now, and which we will present to the committee on the next time we report, is this effectiveness assessment to come and report how effective has this approach been. Now, this slide says the blueprint in the health sector has now been rolled out to the infrastructure built anti-corruption space and the local government, which we have reported. Now, as we implement all of this in improving on the prevention side, and Honorable Chair and Honorable Members will not go line by line on this slide, but it is just important. Mr. Lekgetho, can you go to slide 34 so that the honorable committee members can see that we are partnering with CSIR. Why are we partnering with CSIR? Now, next slides. We want to perform a focused data analytics program. Why are we doing all this? It's because all the law enforcement agencies, we are collecting data, which we are not really using intelligently, so that we can brief and government on the exposures of corruption. So we want to conduct the modeling of the data and come out with predictive view, and that will help government to identify and detect corruption in the space. So the next slide, really 36 indicates where are we going to focus with CSIR, information and cybersecurity, artificial intelligence, and the progress to date is that CSIR is analyzing the PPE investigation and others. We have contacted them. The first set of results should really come out by the end of this quarter, which is around the end of June. So the next time we present, we should present the results, Honorable Chair and Honorable Members. Now, in this space, there's various members of the ACTT. This is collaborative because really we need everyone to pull as if we are to win the fight against corruption. We've done this with the other members of ACTT. We've conducted who should do what. And in this space, you can see the strategic interventions that we have identified and the responsibilities, starting from SSA, National Treasury, Financial Intelligence Center, Competition Commission is also involved. On the next slide shows where SIU is involved. If we identify areas where SIU has to motivate for proclamation, we do so. Implementation of integrity management initiatives, such as lifestyle audits, and we have already started with those. NPA, GCIS, and the last bottom two is the development of the National Corruption Prevention Framework and the development of National Corruption Risk Management Framework. SIU will be dealing with that. The next slide, Honorable Chair, Honorable Members, it's really a summary in one slide of what is it that's going to be done. And we have put this together. We talked to it in the APP on page 53 of the detailed APP. But the National Corruption Prevention Framework will look at who is investigating. This is on the left. In the middle, up middle, prosecutions. Are they running effectively? Are we getting traction? And then the recoveries. Now, if you go at the bottom of the cycle, is the prevention side now. We have done an assessment. We have seen that we need an improvement as government to do prevention. And now on the extreme right, there we go. The Health Sector Anti-Corruption Forum is in place. Infrastructure build is in place. Local government is in place. And those are some of the platforms where we pull the whole of society. to ensure that it's effectively a national corruption prevention framework. We believe that this will be really go a long way in assisting, and we'll continue to report to the Honorable Committee on that. Right, now Part C of our APP, which of course can be found on pages 32 to pages 79 of the detailed APP. Here, we really go into what is it that are the other targets over and above what we have said we are focusing at on the prevention side. This is now investigative and the outcomes that we have put together. We start off with outcome one, which is the high performance SIU that is well capacitated. Honorable Chair and honorable members, you'll see there that number one, we put premium on the governance and controls in SIU. And there, without failure, we want to maintain clean audit going forward. Another important part, which the human capital officer will touch on, is the employee turnover rate. Because as we do our work and as we see the performance trajectory go up, we really want to ensure that the turnover rate is maintained so that we maintain talent. The number of stakeholder engagements around the awareness initiatives, we would also want to ensure that we reach out to the public and inform the public about the SIU work. The next slide really just shows the quarterly targets that we are going to monitor those targets on a quarterly basis. The next set of targets, it's the following: around the civil and other legal proceedings to recover the cash, which is really the key measure of the process which SIU has got end-to-end control on, the civil litigation part. We have to be measured on how best we're doing our work there, because the others, the law says, criminal evidence that we pick up, refer to NPA, and then disciplinary consequence management, refer to state institutions. Of course, we do follow up to ensure that those as well are implemented. But on the civil side, we say in there, there's a row called estimated performance, which is number sort of 2 from the right, which really indicates that it was the baseline from 2022 to 2023. In this APP, we are increasing the rent value of actual cash to rent value of potential cash to be recovered to 400 million. And then 2.2, the rent value of actual cash to be recovered, we're increasing it to 300 million from 275. Rent value of contracts set aside or deemed invalid, the value given the role that we have seen in the special tribunal, the value is increased to 1.9 billion. And the value of potential loss to be prevented, we're increasing it to 700 million. And the next slide is around the target, quarterly targets, without going into detail. And the next set of targets is on slide 16, referring to the referrals now. The referrals for disciplinary action based on the pipeline that we have seen, and the teams have looked at all the cases that are underway, including on the civil recoveries. We have looked at the cases that are underway and we were able to project. So the teams have indicated that in this financial year, we have to really include 185 referrals of disciplinary actions of officials or executives. And a number of referrals made for administrative action increasing to 125. Number of referrals to NPA increasing to 260. Another set of targets, which is next slide, Mr. Lekgetho. Number of investigations closed per published proclamation increasing to 1,550. As we always say, that in a particular in a particular proclamation, if you please go back to slide 47, please. In a particular proclamation, there would be various focus areas that we need to close, and those enable us to reach outcomes. Those looking at the various investigations that are underway, we are projecting that we should reach 1,550 in this financial year. Now, the rand value of matters in respect of which evidence is to be referred to the special tribunal, we have increased it based on the cases that we've seen that are still being investigated. The civil litigation team projects 2.3 billion in that regard. And of course, the number of cases to be referred to special tribunal is 45 in this financial year, and reports to the president to 25. Or even these targets are subjected to quarterly reviews without going through them in detail, Honorable Chair and Honorable Members. The next slide is also quarterly targets of the previous targets. Honorable Chair and Honorable Members, the targets that we have now presented, we thought it appropriate so that we can show the percentage increase in the performance targets to the Honorable Committee, and really without going through them in detail, this would really show the increase that the teams have determined in terms of the target increase. If you can go to the next slide, it's a continuation of just showing the percentage increase. Now, the next slide, it's still a percentage increase of the targets that we have presented before. Now, the next slide of targets is in program 3. It's those allegations that we receive. Program 3 has to make sure that no allegation that is reported goes unassessed or unregistered first, and it doesn't go unassessed. And 100% has to be assessed in any particular financial year. The next slide, Honorable Chair, as you can see, in particular 4.3 at the top, you'll see there that in financial year 2022-2023, we say it's new. It's simply because of the slides we presented before that we need to play a big role in the prevention part of the fight against corruption. We have devised targets to ensure that we play that role and we are measured on those. And this is the number of anti-corruption meetings that we've convened and how effective those would have been as we contribute to the corruption prevention framework. The next one is lifestyle audit conduct. We have seen that this has become another business stream for SIU because the state institutions, departments and SOEs and so on, they have seen that as we do our investigations, we also do lifestyle audits of the people of interest. And we are able to determine whether we should pursue it, either individuals. So now, in this regard, outside of our formal investigations, the state institutions have approached SIU to say, we would like you to conduct lifestyle audits for us, for particular officials. And now we do those on a legal provision in our legislation, which allows SIU to second officials to state institutions to assist with these lifestyle audits. We have seen that they really produce required results. We've done a big project in the Department of Public Works and Infrastructure. Of course, we couldn't detail it here. We'll detail it when we submit our results and the annual report. Now we've been approached by PRASA to do lifestyle audits. We've been approached by other departments in the Northern Cape. So this is really to ensure that we now put it in the APP so that as we expend money or budget on this, we are also measured on it. Slide 4.5 there is really the implementation of data analytics without repeating it, Honorable Chair and Honorable Members. Honorable Chair and Honorable Members, this is the quarterly targets of the program 3 that we have mentioned. We would like to ensure that on a quarterly basis, we review the targets. The next slides really is to give an overview of the budget that supports all these activities for the financial year. For this purpose, I'm going to ask the CFO to really just go over the budget overview for the Honorable Committee. Thank you. CFO, over to you, sir.
Thank you, Advocate.
Thank you.
I've unmuted my video. I'm not sure whether I'm visible and audible. The first slide is just depicts the split of the budget over the next 3 years, the MTF period, per program. And you would notice we've got our normal administration, the back office program, then the core business, which is investigations and legal counsel, and then the newer program, program 3, market data analytics. And you would notice that the majority of the budget obviously goes into investigations and legal counsel. Next slide. This depicts the overall budget over the next 3 years. And you would notice for the 24, the 25, and the 26 year, the first 2 years that we are budgeting for a deficit. So if you look at the total income, just under 1.1 billion, and for the 25 year, 1.2 billion, but then the expenses outstrips in those 2 financial years the income, and therefore leads to a deficit. We engaged, obviously, National Treasury, and we had to get approval. They have done so subject to us funding it ourselves out of our cash reserves that we are luckily still in a position to do so. So we will fund it out of our own reserves. And then for the 3rd year, they've indicated that we need to return to a break-even budget, which we've indicated. And in order to do so, we have increased, you would notice, the investigative services. There's quite a steep increase in order to balance the budget. And we'll do that through increased productivity in the operational space and obviously increased resources. Next slide. This depicts, as at the end of February, we are still compiling the end of March for submission to the AGSA, but I can confirm that the provisional figures at the end of March is around about 830 million, very close to what it was as at the end of February, and you can see the split amongst the spheres of government. Next slide. Not going to go into this. If there's questions, we can take it. This just in more detail depicts per tier of government, and then also with regards to the individual provinces. Next slide. This is just to give some feedback on our what we call Operation Kukela that we launched in August last year. So that is, it was launched in order to have a very focused project on the debt recovery. And it is taking a bit longer than we thought. And I will come to the project plan and how we revised it. But at least we're seeing some initial fruits. And you can see it in the comparison of what we recovered for the 22, the previous financial year. We recovered a total of 236 million. Up to financial year end 31 March this year, we managed to recover 287, and post balance sheet of the year end up until 5 May, 54 million. So you can see if you compare the 236 then with the 341, we've made inroads. What we have learned is you can write a lot of letters and phone calls, but it is better to have face-to-face meetings, and we've obviously engaged in that. But for that reason, because it takes a bit longer, we had to revise the end date of Operation Kukela towards October, November. And I just want to mention, since our last meeting and our presentation on debtors to the committee, included in that 341 million is a figure of 64.2 million that Department of Justice has paid us. That was under discussion in the last meeting. Next slide. This is just high-level overview of the project. And you would notice, Chair and members, towards October, November, this is where we get to the steps where we escalate to our minister, who will then, we will draft individual letters to the individual state institutions, to the relevant executive authorities, and ultimately prepare a cabinet memo that will then be taken to cabinet by our minister. And I think the next slide would be the last slide, although it's, yeah, it is theoretic, it is not, it's academic more. At the end of February, the figure was 177, but as I've said, towards the end of to 5 May, it was a total figure of 341 million, where we received payments. Thank you, Honourable Chair and members. That is the financial portion.
Thank you, Honourable Chair and Honourable members. Mr. Lefeto, can you go to slide 65? What I want to mention on this, it's still part of the finance part. What I want to emphasize to the Honourable Chair and Honourable members is we do, on an ongoing basis, do an analysis of the increase, the allegations that are coming in, and the increase of the proclamations. We really do an assessment of the continuous capacity that we require to ensure that we execute successfully on the investigations of these proclamations. And we continue to see really related results on that, which we can possibly present to the Honourable Committee at the next reporting cycles, or as and when the committee would deem appropriate. We've seen results in the LOTO environment. We've seen results in the NSFAS. So that this has been the result of ensuring that we really capacitate the proclamation as and when they come, and we're able to show the projection in terms, as at the end of February 2023, we've seen the projected increase of about 83%, or average year-on-year increase. And then, as you can see there, the other yellow arrow at the top is the planned headcount that we pair with all of this. So we really continuously do that. And at this stage, to then support all this process is the human capital strategy to ensure that we do this effectively. And that leads me now to slide 67, which is the human capital overview. I think we've touched on slide 67. Human capital overview. Honorable Chair, I'm going to ask our Chief Human Capital Officer to come in and give the honorable members an approach of the human capital space, so that we don't drop the ball in terms of the capacity as and when we require. I think it's important to know that we continue to recruit so that we really ensure appropriate capacity with the budget that we have. My colleague, Chief Human Capital Officer.
Good afternoon, Chairperson. Not sure if I'm visible and audible.
Yes,
good afternoon. Thank you.
You
Good
are.
afternoon, Chairperson, committee members, head of the unit, and my colleagues. With regards to capacitation of the SIU, we've ended the year with a staff complement of 601, of which in that total number, at least 7 of those, which is 1.2%, are people with disabilities. This total number as compared to last year, of course, is an improved capacitation, wherein we were sitting at 587. The SIU has, in the short term, stabilized a huge resourcing deficit capacity. The planned vacancy rate, as you would recall, we agreed that we would do a downscaling vacancy rate, which was planned at 12%. We've reduced that to 7.5% as compared to the previous year at 13%. Due to, of course, the growing business needs and our funding model, the organization has adopted other co-sourcing models such as fixed-term contractors, independent contractors, and of course, consultants. We continue to build capacity to address the current resourcing needs, such as lifestyle audits, as the head of the unit has indicated, specialized forensic skills, and of course, future resourcing needs. We are, of course, well aware, Chairperson, of our challenges in terms of the aging workforce. The organization has, as a result, continued to attract young people and ensured that we address the scarce skills gaps. And in the quest of doing so, we've onboarded 21 LLB graduates and internal admin colleagues who have completed a TFI program to junior forensics investigations positions. We've also entered into an agreement with the Northwest University, wherein we are funding at least 15 forensic accountants at undergraduate degrees as well as honors degrees. We further funding our own SIU members, about 16 of those who are pursuing an integrated forensic accounting learning program with the Northwest Universities. We further onboarded 22 other interns in a multidisciplinary internship program who are meant to enable and support the enablement areas. It is our commitment as well, Chairperson and committee members, to advance a transformation agenda. Our EE plan, as well as the EE measures implemented by the unit, is a commitment and a display of this concerted efforts to achieve the objective. The ratio, as we speak today, is that males to female is at 1:1. We are 50-50% with 6 of those at senior management being females out of 19 at the top management of the organization, and 39 of those at senior management being females out of the total of 109. With regards to the staff turnover, we are monitoring this particular target in line with our commitment for this particular financial year. Let's go to the next slide. The SIU is committed to enhancing its organization with an EVP that can be reckoned with. And recently we've offered our members a medical aid allowance, and GEMS being the preferred medical aid. Leadership and forensics capabilities are built continuously to, of course, ensure that we are able to execute on the mandate of this organization, especially in the fields of forensics, cyber, and data analytics. If we can move on, Mr. Lekgetho, in 2017, the SIU entered into a partnership with the French Embassy to build the SIU cyber forensic investigations capabilities. And at least during that period, 30 SIU trainers were accredited. The SIU, during this collaboration efforts, then continued to share expertise with other anti-corruption law enforcement and law enforcement agencies within South Africa, SADC member states, as well as the Commonwealth member states. In the past 5 years, the SIU contributed extensively towards the development of the cyber forensic investigations curriculum and the rollout of the pilot training project to ACTT members, SADC member states, as well as Commonwealth member states. To date, more than 500 investigators have been trained. If we can go, please, to the next slides. This relationship, Chairperson and committee members, have now developed to a point where the Republic of South Africa and the French Government Republic are ready to enter into a cooperation protocol. The aim of the protocol is to further strengthen capabilities such as data analytics capabilities, forensic skills, and other related skills that will enable ACA, LEAS, domestically, regionally, and beyond to effectively deal with cyber forensic related investigations, financial crime investigations, corruption investigations, and others. This cooperation will, of course, give effect to the establishment of an anti-corruption academy, and this process is underway. We have been granted an opportunity to utilize the premises together with the Justice College. The academy will serve as a catalyst to capacitate and promote collaboration, as well as sharing of expertise with the member states, the local anti-corruption agencies, and EU, as well as, of course, the French government have agreed to come on board as our partners. And ultimately, we want to ensure that we encourage the importance of an international approach to capacity building. The signing of this protocol will take place on the 19th of June, and it is intended that the protocol will be signed by the Minister of Justice and Correctional Services on behalf of South Africa, as well as the Minister of Europe and Foreign Affairs on behalf of the French Government Republic. That is the human capital report, and thank you very much.
Thank you very much, Chief Human Capital Officer. This slide that the Honorable Committee is seeing is a continuation of the Anti-Corruption Academy. Mr. Slekhetho, slide on. Again, it's the establishment of the African Regional School that my colleague referred to. Mr. Lekhetho, I think the slides, I'm not sure if you're sliding forward quickly. Honorable members, apologies for this. We are now in the international relations side, where we said to the Honorable Committee that SIU is playing a key role with other law enforcement agencies, of course, in the ACTT space. But we thought it appropriate that honestly, they should be included in the APP so that we are measured on this, because we are spending budget as we do this work, but we also need to show the returns thereof. The next slide is really some of the international platforms that we are participating in. International Association of Anti-Corruption Authorities. We are a deputy president there. The president is Hong Kong, China, and it includes the next one, the African Association of Anti-Corruption Authorities. We are also active in the African Union Advisory Board Against Corruption, Commonwealth Africa, Southern, which is SADC, Anti-Corruption, and the Globe Network, which looks at various entities and ensure that there's collaboration. And of course, our role in the Financial Action Task Force that is coordinated by National Treasury. The next slide is really just depicts some of these organizations by their logos. The next slide really just details now what is it that SIU is doing, including in the United Nations Office on Drug and Crime. They've partnered with South Africa, with various law enforcement agencies, but the SIU is also part of that. Next slide, please. Next slide, it's just the details of what are we really doing under those various associations. Next slide. Again, it's just the details of what we're doing there. Next slide, please. This is the SADC part, which details the nature of what we have done. It's still SADC. Next slide, please. Globe Network and Financial Task Team. Honorable members, we thought we would close our presentation with really looking at what, high-level future focus. If you slide on, the next slide, which is really the last slide, is that we want to really continue to focus on the vision of SIU to being, an effective forensic investigating and civil litigation unit that also helps on the prevention side. and that's the next block around prevention. We place premium and importance on the collaboration with other law enforcement agencies in the ACTT and individually. We've got MOU with NPA, we've got MOU with SARS, we've got MOU with FIC. So that's the important part, so that we all play in this role and then all bring our part. Of course, supported by the digitization program that we have. Just to conclude, all this work, of course, is supported by a detailed risk assessment. And in the APP, in the detailed APP, we do indicate the updated risks per outcome. So those are covered there, and we continue to monitor those risks so that our APP is not derailed. Honorable Chair and honorable members, we thank you for the opportunity to present. Thank you. Thank you, Honorable Chair.
Afternoon, Advocate Mthibi and members. I've just gotten in touch with the chair. He's been cut off by load shedding, which should come back at 2. Normally, it will come back around about 5 minutes after 2 and so forth. So I suggest maybe we take a breather of about 5 minutes, and then when the chair reconnects, we will then continue.
Okay, thank you very much. We'll stay connected.
Thanks.
Thank you.
and to the honorable members. You can proceed, Advocate Mchebe.
No, thank you, Honorable Chair. Being unaware that the chair was cut out, we proceeded actually to the end of the presentation. So we're at the stage where we are in the committee's hands, whether there are any questions to ask.
I think Honorable Breitenbach was listening on my behalf. Members,
Was indeed, yeah.
are there any questions or comments? Honorable Horn? Yeah, Honorable Horn, Honorable Nibos, Johan, Honorable Breitenbach, in that order.
Yes, thank you, Chair, and yeah, good afternoon from my side, and thank you for the presentation. Chair, I have a few follow-up questions following from the presentation, and one or two that's not strictly related to the presentation. The first is on the funding model, and while we appreciate that the conversation is ongoing, our understanding is that Treasury for now has said that it is not of the view that to go to a model where grant funding would be the primary driver of the funding of the SIU. I think we must interrogate as to whether the second option on the table, and that's the option of then at least negotiating with Treasury that in circumstances where there is a continued or a persistent failure to pay from departments, provinces, etc., whether a garnishing model could be used, and that the amounts owed to the SIU could then be deducted before any grants are paid to that province or entity or department. So I want to ask whether that has now been considered and whether that is indeed part of the negotiations or the conversations. And then, Chair, in respect of the special tribunal, it's now, I think, enough of time has now spent, or enough cases has been driven through the SIU for us to maybe ask that an assessment at some stage be done as to the successful operation, hopefully, of the SIU, mindful of the fact that, of course, there is a removal, strictly speaking, from the SIU. But I think that the question must now be asked as to case flow and case progress in the High Courts versus the Special Tribunal, and what could be done to ensure a proper case flow management in both institutions with those cases that still remain with the High Courts. And then secondly, Chair, if our understanding is correct, that it would seem that of the 5 part-time judges allocated to the SIU, only 2 are active. So it would be good to hear from the SIU whether that is indeed the case, and then consider what could be done to address that specific situation. Then, as always, we, as part of these engagements with the SIU, although it's a bit of an, let's say, I don't want to say an abuse of the platform, it's our special interest, an inquiry once again into the investigation specifically relating to the departments we are overseeing. So that would be the Department of Justice and Correctional Services, and as whether we could be brought up to date on those referrals. And then lastly, Chair, on the issue of whistleblowers and the, let's say, the inability to properly protect whistleblowers is identified in the APP by the SIU as its most significant risk. Now, my reading of the situation is that this is, of course, relevant in two contexts. The first being internally, and in that sense, the question is whether the SIU have further considered and strengthened its own internal whistleblower protection protocol or framework. But then secondly, Chair, I think there is a realization that the work of the SIU is also being undermined by our country's inability to give proper protection to whistleblowers. And in that sense, it's interesting that, well, some of the measures introduced there is the continued engagement with accounting officers of the various departments, which of course might bear, with respect to limited results. Then, since the identifying whistleblowers and witnesses involved in sensitive investigations, conducting one-on-one awareness training, that seemingly also, Chair, presupposes that we must stick with the current national protocol in terms of whistleblower protection. So the question really following from that is whether the SIU has anything to add to the process that hopefully will unfold in the very near future to, from a national perspective, strengthen the whistleblowing protection framework in this country through either legislation or policies that doesn't need legislative amendments. So it would be good to hear what the SIU could add in that regard. And then maybe on the last issue I have on this is that one of the contributing factors identified is that the threat risk assessments from the SAP seems to be a somewhat protracted process. So I don't know whether Advocate Mutibi and the team can share with us what the typical period would be which such a risk assessment would take, what they would deem and to be a, let's say, reasonable period, whether they've had engagement with SAPs to try and see whether that could be addressed. So maybe to just bring us a bit better into the picture regarding that specific issue. Thank you, Chair.
Honorable Neville Trochen.
Thank you very much, Chairperson, and thank you to all the members of the SIU. Thank you for the presentation. And thank you for all the hard work that you have been doing over these past years. I would like to ask about the funding model. You've indicated that Treasury says Treasury does not support your proposed funding model. I would like to understand what in particular, or what is Treasury's reasoning for not supporting the funding model that you have proposed? And does Treasury give any assistance to the SIU in terms of debt collecting? Also, in relation to that, on slide 21, it says total whistleblower referrals and highest payment irregularities. So with regards to this, the SIU, does it give assistance to the departments who have these payment irregularities? One of them is nepotism and cronyism. So how does the SIU advise departments on how to deal with that? And reporting or reports from from SIU Investigations, sent to about the Master's Office, State Attorney's Office, and the building or construction issues. Has the SIU released the reports as yet? And I would like an update, excuse me, in that regard. We also see a lot in the media or in the newspapers, they say that they speak about the mafias in the construction industry. And I'd like to know then, you know, how does the SIU assist to combat these mafias who are continuously disrupting the construction, you know, activities, and, you know, it's in matters that go to court. So what does the SIU do to assist in that industry? And I'm just going through my notes. I think it's on slide 32. Yes, slide 32. In the SIU presentation with regards to common root causes and key vulnerabilities identified. There's a list there. For example, lack of consequence management is actually top of the list. What is the SIU's advice in terms of all of these root causes and what has been done, you know, by the departments? We constantly hear of these root causes, but what exactly is being done about them to eliminate them? And then operational cocula. Don't know if the interpreters pronounced that correctly. National Treasury and the Department of Justice, do they give assistance to the SIU with regards to that? I see that, well, in the presentation, the SIU head has mentioned that there are face-to-face meetings, but I mean, the payment needs to take place. So what assistance does Treasury give the SIU? That's all from me now, Chair. Thank you.
Thank you, Honorable Breitenbach.
Thanks, Chair. Good afternoon to everybody. I'm covered by my colleagues besides one aspect.
Apologies, Honorable Breitenbach. Can the Secretariat unpin? Thank you.
I'm covered except for one aspect, Chair. I've read some reports about special investigation unit investigators being threatened, being exposed to danger. That's obviously an item that hasn't been budgeted for, but it's probably an item that's going to crop up more and more often now, because, you know, as soon as you start going after the big guys, this kind of thing is going to continue to happen. So I'd like a little bit more detail about how the SIU is going to manage that, given that it probably is an item that wasn't budgeted for, and whether they're getting sufficient cooperation from other government departments in protecting their staff. It's important to protect whistleblowers, but it's equally important to protect the people who are doing the investigations. Thank you, Chair.
Thank you very much. Did the Department of Justice pay you the outstanding amount after the meeting we had with yourselves and them in Cape Town? Over to you, Advocate Mchibi.
No, thank you. Thank you, Honorable Chair and Honorable members. We are really appreciative of those questions that would guide us in terms of some of the next steps we need to do. Honorable Horn, on the funding model, we really approached the National Treasury and also sought their view so that we can include it in the legislative amendment that we have submitted to the Department of Justice. So their view, and which when I spoke to the CFO, is more is more slanted to the view that we must collect the debt. They seem to link the review of the funding model to the fact that we need to collect the debt. And that's, we believe that they might have sort of missed the principle there. Because the principle in the main, and if we benchmark what SIU is doing with other similar agencies, is that if we go on the fee for service model, more often the findings, negative findings, are produced to the senior management of these state institutions, and it may be that this lack of enthusiasm in paying is linked to that. So other like agencies are fully funded from the fiscal. So our continued engagement with them is to show them really that the funding model is not necessarily all of it linked to the debt recovery. But for now, we really appreciate that view, and the CFO can come in. I don't recall that we actually considered this Ganishi approach, which will really, I think, help us, because this could be implemented with immediate effect. Of course, based on some of the directives that the National Treasury could give. Perhaps the CFO, if you've got a comment on this, you can come in. I think we need to approach National Treasury now based on the need to implement the Ganishi model, so that when they allocate, so what we could do is, of course, furnish them with a list of the debtors, and they could, extrapolate their reports to the debtors, and then subtract what's owed to the SIU. So we will pursue that. CFO, you can comment if you've got views once I'm done with the questions. On the special tribunal, we really appreciate that view, Honorable Horn. I think we are at the stage now where we really have to just show, as I said, the challenge by these litigants whom we are vigorously litigating against and freezing their assets, forfeiting their assets. They now realize that the special tribunal is speedier, and then they sought to challenge it. Of course, as I said, they failed, and the Constitutional Court has given it a thumbs up. So that has resulted in a bit of a slow, but we will ensure that now all of those cases are case managed appropriately. Now we will provide the Honorable Committee now with a detailed view of the High Court matters and the Special Tribunal matters. As I said in the presentation, that you will see the view in the High Courts that some of the cases, date back to, quite a number of years back. And of course, we will really appreciate the extent to which the committee could go in assisting. As we said, we engaged with the Department of Justice. They did indicate, and the minister in particular said, no, there's nothing wrong in approaching the judge presidents to seek what call it intervention in terms of how they could speed up the matters in the courts. But we will provide that view. Only 2 judges are active. I really, at the last check, my colleague, Dr. Wells, is in the meeting. So we've realized that they're using a sort of 2 approach here. Some of the judges are still based in their courts. Like, for example, in the KZN, you've got 1 judge who's allocated to the special tribunal, but is based in KZN. In various provinces as well, there's only few that are full-time at Boysens in Johannesburg here. So those that are still based in their jurisdictions, they do High Court matters and they do special tribunal matters at the same time. So that could probably, you know, be addressed, and we would really like to see where judges are 100% allocated to the special tribunal, and that will now really speed up this recoveries, and those who we have made findings against and we seek to act upon, they will see now the speedy recoveries. Investigations in the DOJ, Honorable Hon, Mr. Lekete, remember we spoke about this, that we need to be ready to update the committee on the matters under the portfolio of Department of Justice. I hope you are ready to do so. Just please hang on, and then you can come in. Inability to protect whistleblowers, internal protection mechanism. Honorable Hon, thanks for that question. Of course, we do as best as we can with the financial resources that we have. And Mr. Mkungo, the Chief Risk Officer in the meeting, it's in his space. Once every witness, comes up and say, you know, they are experiencing a threat. We've got one witness in one of the cases in the Free State who came up. In fact, he happened to be an investigator and also a key witness identified by NPA. So we internally put aside measures which were, of course, costly in terms of ensuring that he is protected at home, in transit. So that was really quite pricey. He has since left SIU. So to a large extent, we could probably hand over to NPA, and I don't have the recent update whether he's been taken on to the witness protection on the NPA side. But we do really do our best so that we identify together with crime intelligence, and that also goes to the next question in terms of the threat analysis. That takes a while to be concluded. The recent example is in the Free State. No, I'm sorry, in the Eastern Cape with the Fort Hare investigations. There, both our investigators and some of the witnesses who are based at the Fort Hare University came up and said, with what's happening there, the threats and all of that, we engaged with the criminal CI, Crime Investigation Unit. Of course, they came to the board, to the table, they did threat analysis, but we really believe that it took a while. Our expectation, Honorable Hon, in terms of timeline, because it's lives at risk here. We would expect that, you know, that assessment really should not take more than 2 weeks. It might be too ambitious, but because it's lives that are at risk, we expect it to be done as speedily as possible. We've engaged with the head of crime intelligence to bring up our views, and we really believe that they will take that on board on the next request for threat assessments. Strengthening the national program of protect witnesses. Oh yes, as I indicated, that we were actually specifically called in by the Department of Justice, together with NPA, together with DPCI, to form part of the project team that looks into this. So we will share our experiences, and the project team went out actually to Canada to go and benchmark, and then they came back with a report which was incorporated into this process. So we really look forward to this process unfolding into appropriate legislative changes that would, having listened to some of the scenarios, even some of the witnesses that testified at the Zondo Commission. I think their stories, were listened to in terms of how is it that they were of the view that they are not protected. Honorable Nivo Drachen, funding model, what is Treasury's reasoning? As I indicated earlier on, that we believe that National Treasury may have missed the principle which we were presenting forward over and above debt recovery, but our principle and probably policy that should be considered is that agencies like SIU should be fully funded from the Treasury. And we will also now take into account what Honorable Horn has indicated and re-engage Treasury on this Ganeshi approach. Do they give assistance on debt collection? Yes, they do. The last time we engaged with the DG of National Treasury, we indicated that we are going to now speed up our process as the CFO has indicated in terms of the project to recover. This project Kokela that Honorable Nivo Drachen referred to, it's called Project Kokela, simply meaning project to ensure that the state institutions pay. There has been quite an intense engagement with the state institutions, including the Department of Justice, where the engagement, number one, is to show them how the investigations has progressed, what outcomes have been reached, what referrals have been made, what systemic recommendations have been made, referrals to NPA, any recoveries, any cases at the special tribunal, so that they can see what is it that has really been done to enable them to be able to say, oh yes, we can see what you've done. We then can honor your invoice. So that has been done across all the state institutions, and hence this traction in terms of some of the payments that are coming in. The report from Masters OSA, Office of the State Attorney, building, Mr. Lekete is on standby to give the Honorable Committee high-level report. The mafias in the construction. This is really so pleasing that this question has come up. In the Infrastructure Build Anti-Corruption Forum, which we started, and it was launched by the Minister of Public Works and Infrastructure. Amongst other risks that have been identified, it's this mafia in the construction industry, where they just pounce on any development. The local people pounce there and they demand 30% of the value of the contract. If you don't pay, the project stalls and it stops. And we have seen this on a large scale. So as part of the Infrastructure Anti-Corruption Forum and in the ACTT, where this has been identified as a focus area, and the DPCI has, I think, formed a team that would really deal with this. We have also shared our experiences in the investigations that we've done in the public works space, where we've reached significant outcomes, and those have been recorded, and we have now shared our views with the DPCI, because this is sheer criminality that needs to be nipped in the bud. So that risk has been monitored together with the DPCI, and they keep on reporting at ACTT and also at the Infrastructure Build Anti-Corruption Forum. The root causes, amongst others, lack of consequence management. This is a perennial problem, and we've raised it with the state institutions, but in its wider sense, lack of consequence management would include the speed at which we would like to see prosecution going. So in this regard, and we are glad that the presidency has established a specific project, and I know that they are ready to give update if the portfolio committee is in a position to call on them to come and really indicate they have a specific project. We are part of that, and other state departments. Now, what do? They have to date written to all the state institutions, including writing to NPA in terms of ensuring that they monitor the referrals of SIU. And so the accounting officers and accounting authorities are requested to give update as part of monitoring the reports of SIU to the presidency. We are really pleased, and there's even a system that has been developed. We really look forward that there should be a report that comes out of this project, which can be tabled, probably even at the portfolio committee, just to show the picture that this lack of consequence management is now being addressed vigorously. And we are really happy because we made this call that we are seeing that our referrals are not really receiving the attention that's required, and it's really not acceptable. Honorable Brayton Bath, again, thank you very much for the investigation, for the question. The protection of investigators, it's very, very key as well, equally to the whistleblowers. And again, we've got recent examples where our investigators were literally threatened in the Lotto environment, in the Lotto investigation. Of course, without going into details, but we've had to give a budget, and through the office of the CRO that does internal investigations. Again, we included the threat assessment with the crime intelligence. They've done that, and the threats were positive. We had to, with the budget that we have, ensure that there's protection there. Our investigators in the Eastern Cape has also indicated that with the 40 investigations, there's indications of threats. We've had to come in. So the issues of budget, I think it's very accurate that some of these threats would crop up during the investigations, and they would not necessarily be budgeted for. Now, as we raised this, I raised this before with the CFO and of course the CRO, that this is going to be one of the cost drivers as we do our business, right? So with the new MTEF program, we have sought to at least raise some funds, not really funds, but the budget allocation on this business stream, so that from time to time we are able to come in when our investigators are at threat. Honorable Chair, the Department of Justice, I think the CFO mentioned. CFO, if you can come in specifically, since the last meeting we received, we had with the portfolio committee what has been the payment from the Department of Justice. And as you come in, please address the issue around whether we've at any stage engaged National Treasury on the Ganishi model that Honorable Horn has really put forward, which I am of the view that it will be helpful. And then, Mr. Lekgetho, you can come in with the updates on the investigations in the justice portfolio. Honorable CFO.
Thank you, Advocate Matibi, and thank you, Honorable Horn, for the input. What we have pursued with National Treasury, it's the same principle, but a slight variation to the Ganishi principle, is that upfront, when we budget during the E&E MTF budget processes, that National Treasury takes away effectively the funds from, at least on national department level and provincial level, take it away, pool it somewhere, either with themselves or with the presidency, so that when we invoice, we don't invoice the institution itself, that we invoice then the presidency, Department of Justice, or National Treasury directly. So we left that open. We do suspect that those taking budgets away are not easy discussions, So although it's technically possible, National Treasury shied a bit away from it. Now, what you're putting on the table is a bit different. That is what is called proven debt in legal terms. So that might be an easier way because those services have been rendered. It's not forecasted money. It is an actual invoice. In other words, they could, during the budgeting process, and we prove the debt to them, be able to take it away because it is already proven debt. So thank you for that. We'll definitely consider and take that up. We haven't taken it up in directly in such a fashion as you're putting on the table. Yes, the Treasury is, as Advocate Motivi is saying, they are assisting us, and we will, with regards to letters and putting pressure on the tiers of government, which is the provinces and then the municipalities. With regards to Department of Justice, they owed us at the end of January 72.1 million. As I've mentioned, they paid 64.2 million. So there's still 11.1 million outstanding, and that is relating to a specific investigation. And they are currently in discussions again with our operational team in order to sort either the progress reports or the outputs out so that they can then pay us for the remainder. Thank you very much.
Thank you, CFO. Mr. Lekgetho, if you can come in, please, with the high-level updates on the investigations in the Department of Justice portfolio. Thank you.
No, thanks, Advocate. Thanks, Honorable Chair, and thanks, honorable members and the colleagues present in the meeting. With regard to the Department of Justice, we've got 3 proclamations, which is the first one relating to Master's Office, and the second one is the Office of the State Attorney, and the last one is the Department of Justice, which is in relation to building of courts. With regard to the Master's investigation, the investigation is almost finalized. Currently, we had 23 matters which were mentioned in the proclamation when we received the proclamation, and those matters are finalized. And after receiving the proclamation, we further received 250 referrals from whistleblower where we investigated those matters. And currently we are left with 9 matters which were all currently at the reporting level, whereby the entire investigation is finalized. The challenge with regard to this investigation is because as and when we finalize, we keep on receiving new allegations. And if they are covered by the proclamation, we are enjoined to investigate them. With regard to the outcomes, today, with regard to NPA referrals, we have referred 38 referrals to NPA. And disciplinary referrals, we have done 20 to the Department of Justice, and we have referred 6 referrals to professional bodies, which relates to some of the lawyers. And there's also 3 referrals that we have done to the Asset Forfeiture Unit. So that's the outcome pertaining to the Master's Office. And we are hoping that by the end of May, June, we should be done with the presidential report when we finalize the last 9 matters. With regard to State Attorney also, the Office of the State Attorney, the investigation is finalized. And there, currently the team is supporting the matters that we have referred for civil litigation. And also we have appointed a cost consultant so that he can come and do the quantification for other matters that we need to submit to special tribunal so that we can recover the cost there. With regard to the investigation, we have looked at 18 lawyers, that is both advocate and attorneys. And with regard to the outcome to date, we have referred 20 referrals to NPA in relation to criminal act that has been done by some of the members of the legal profession and also members from the state attorney. And we have also referred 11 referrals for DC to the department. And with regard to professional bodies, we have referred 14 lawyers so that action can be taken against them regarding their conduct. And on the issue of the civil matters, currently we've got 19 matters in the civil matters space to the value of 600 million that we are currently busy supporting to make sure that we get the money that has been siphoned out of the Department of Justice. And lastly, there's 3 blacklisting referrals that we have done to the department so that they can blacklist some of the service providers that were enjoined in terms of corruption in the Department of Justice. Then with regard to the building of courts proclamation, the investigation also is completed. There we have done six NPA referrals, and we have done 6 SARS referrals. And with regard to this one, we couldn't do the DC referrals because all the members that we wanted to discipline on these matters, some of them have resigned, some of them are deceased, so we couldn't make referrals for those members. And this investigation, Honorable Chair, we had so much challenge with regard to documents because the investigation spanned from quite far years. And as a result, we didn't really get most of the document that we needed in order to finalize some of the issues pertaining to this investigation. There were a lot of variation orders which were authorized by IDT without going through to the Department of Justice. And there's a lot of money that has been paid. And I can indicate that we appointed a quantity surveyor so that he can look at all the courts that were built to see whether there was value for money. With regard to all other courts that was meant to be built, they were built in accordance to the budget. The problem we had was the court, the Mpumalanga court and the Limpopo court, where we have noticed some structural defect. And there were also issue of drainage where the court was built, where there were no proper drainage. And there were also issues of poor plannings and lift not working in some of the court, and whereby there were issue of the power supply in some of the courts. So currently the team is wrapping up in order to make sure that we have identified all the people that are responsible and action is taken against all the members. So those are the proclamation in relation to the Department of Justice. With regard to the Department of Correctional Services, there were also some other investigations that we have done. The first one is in relation to the IDT, the fencing of correctional services. There, the investigation is finalized, where we have done 4 NPA referrals, and we have done 3 disciplinary referrals, and we have done 2 blacklisting. And currently, we have taken the contractors to court, where we are in the process of recovering the money that has been lost by the department. Then the other matters that we have done is the DCS KZN investigation, where the investigation is also finalized and the report is submitted to the president. And in terms of the referrals for criminal to the NPA, we have done 16. And for disciplinary referrals, we have done 22. Blacklisting is 6. SARS referrals is 2. And referrals to asset forfeiture unit is 3. And other matters, Chair, that we have also investigated, we have reported many times, an investigation were finalized a long time ago, is with regard to the ESS matters and the MSW. So those matters we have reported many times, and there's no change with regard to the outcome on those matters. That's an update from the matters in relation to the portfolio of justice. Thank you, Chair.
No, thank you, Mr. Lekgetho. Honorable Chair, that's, as we said, that's high level. For the record, we could provide the Honorable Committee with what Mr. Lekgetho has just spoken to. If the committee so requires. Alternatively, we could come and present to the committee in detail the reports that Mr. Lekgetho was talking from. Thank you.
No, thank you very much, Advocate Mchebe, and to your team for the good work that you are doing. Certainly, I think we should set aside time for an in-depth briefing on some of those issues relating to justice and correctional services. But I also thought that, I might be wrong, but I also thought that your response to a question that was raised by Honorable Breitenbach with regard to security of the people who are working for the NPA. I got a sense that you're extremely guarded, which is understandable. But I do think that I think we need to have time. Maybe we need to apply to the speaker because it's a security matter.
Indeed.
Where we can get an in-depth a briefing on that, because
yes,
we always say that South Africa is faced with the triple challenges: poverty, unemployment, and inequality. But I think the issue of crime and corruption is at that level now, where we should be regarding it as one of the serious challenges facing our country. And the more institutions like the SIU are making headways, is the more you are going to get a resistance, even a violent one. How do we as a country with yourselves respond to that? And it will be very important, because it would be important that the SIU retains and even grows the capacity it has, and then we do not have people resigning because they fear for their lives. And that would also be linked to how this issue of budgeting is finally resolved, because you cannot have the resources to fight this pandemic, which is crime and corruption, without being properly resourced. Globally, criminals are now at a stage where sometimes they're more advanced and they have more advanced technologies and capacities, some even more than some departments or states. Now, we cannot continue in the manner in which we are continuing in how we view budgeting of crime fighting or corruption fighting entities. That will talk to yourselves, to the NPA, to intelligence, because we are also dependent on also how fast and how capable some of these entities are in order for your entity to excel. And also, I think on their side, they are also dependent on how proficient and how efficient you are in executing your mandate. So we should have a whole of government approach in dealing with the issue of crime and corruption. And I suggest that we package this into two. There are things that can be done this year, and there are things that we should package them as part of our exit report, which but needs to be prioritized by the 7th administration or 7th parliament as a matter of urgency. Because, I mean, I think there's legislation that I think would need to be prioritized that deals with the architecture of the entities. For instance, you talk about the funding model of the SIU, you talk about the act that predates the Constitution as far as the public protector is concerned. So there are those legislations that we could not deal with in the 6th administration, which we will prioritize, that we will recommend that the 7th parliament should prioritize them. So it will be important for institutions like yourself to say, what will be those 3 important areas that if you think that through legislation are addressed, they will be able to take your work to the next level. Then there is this innovative idea, which I think it will not only be yourselves that will be interested in it. I think there are other departments that might also be interested in the Honorable Horn's innovative intervention, which will still need to be engaged. But that is what I think that is very important to us as politicians, as managers in state and as leaders, that at this time we need more thinking out of the box, creativity. I think I was kicked out by Honorable Horn. So we need a lot of that creativity to be able to deal with the challenges that are facing our country. And some of those innovative interventions don't even need policy or legislative amendments, but we generally, as leaders and as managers, we need to encourage thinking out of the box. But as usual, thank you very much. Every time we listen to you, we are always encouraged that there are institutions that are doing a bit to ensure that we push back the front of crime and corruption in our country. Thank you very much.
No, thank you, Chair. Thank you, honourable members. We would be pleased to come and share in detail some of those security threats with the portfolio committee at an appropriate time. Thank you.
Thank you very much. Thank you very much, members. Is there any issue that you would want to raise? None. We will meet on Tuesday. Thank you very much.
Thank you, Chair. Thank you, honourable members.
Thank you.
Thank you.